Please, Your Lordship. Today, Your Lordship is hearing item number 12 to 17. Lordship, I also have lots of matters relating to the same matters. So I may also be heard before giving judgment, Lordship. One matter is fixed. And Lordship, there is one more motion which has not yet come. I would like to mention that matter also. So I may also be heard along with these matters. So give me opportunity of hearing. I'm giving the list, mention memo for 1 or 2 matters which has not been listed. And there are other list of matters, Lordship, that has not yet been listed. Interim order has already been passed, but they are similar matters. I'll give a list also. Lordship, all these matters may be...
See, when these are the matters which are before this court,
Yes,
you
sir.
want to be heard, I can hear you.
Yes,
It's a
sir.
different thing.
I prepared a
Have something to do with regards some other matters, I can give you a hearing on that. But otherwise, I'm not calling any matters today.
Lordship, at least this matters may kindly be listed tomorrow, Lord.
People listing of the IA on Monday, Lord.
Why?
Or modification of an order, Lord.
Why?
There earlier on 22/7 elected to take an inquiry to the Tinsukia Municipal Board, and while directed the municipal board to measure the height from the roof of the basement floor. For the rule, in our opinion, the case of a building with the basement floor, measurement has to be done from the ground floor level. Because as per definition of 215 of the rule building rules 2014.
Yeah, there is a direction to the, not to the municipal board to do it.
Yeah, to the deputy commissioner. Lord.
Let the matter come up along with that. I fixed the date. No?
Date fixed on 12th.
We'll see when the matter comes. As of now, what is there? There's nothing out there. We'll pick it up when the matter comes.
Public.
I beg to mention WPC 3025/2023 for listing on 7th.
May I mention a matter for listing orders regarding the restoration of GST
For admission.
orders.
Right? Anyways. 7th.
Wait.
Item number 1, top of the list.
Your Lordship, just to refresh the things, page number 15. Here, Your Lordship, we have challenged the 34 order dated 14 August 2017, Lordship. And I like to draw the attention on the last para of the order, page 28, Your Lordship. Page 28, Your Lordship. According to the Amendment Act of 2015, an arbitral award can be set aside if procured by the penetrating the fraud. This is the substantive law. This law cannot be applied prospectively to the present case because the application of this law at this stage would affect the opposite party. So, Your Lordship, as per the observation of the court, the fraudulent, this law has come in 2015. However, the fact is that this law has come in the world in 1802, first time in England. This is the first ground that on that basis the award can be set aside. Then the legal error has come later on in 1923, Your Lordship. So this observation reflects, and Your Lordship, I like to draw the attention on page number 72, Your Lordship. On page number 72, Your Lordship, we have given the grounds 72 to 83 pages, Your Lordship. We have given 12 grounds to set aside the award because there is a direct violation of the substantive law, a stock market uses, trade and uses of the market, Your Lordship. And Your Lordship, the law says that any award in non-compliance of the Arbitration Act itself will be against the public policy of India. Section 28, subsection 3 says that awards should be passed keeping in mind the trade uses, market dynamics and the market practices, Your Lordship. Your Lordship, this constituent was making the transactions in the currency segment, Your Lordship. The transaction has taken place from July 2012, Your Lordship, to March 2013, Your Lordship. I proceed, your lordship?
Yes,
Yes.
please.
So, your lordship, I have started from page number 72. I have mentioned 12 grounds, and your lordship, this case is completely different than the other case, your lordship. As far as the fraud ground is,
Records have not come. Where is your application for under 34? Where is your application under 34?
That has not been annexed, but,
that has not been.
but I have the copy, madam. And it is silent about that fraud part.
Huh?
It is totally silent about fraud part.
This is why I asked.
And even my lord, first and second round also, there is no any whisper about fraud, my lord. And lordship already decided this issue in a similar manner. It is totally silent about it. Argument will not serve any purpose.
This case is completely different, your lordship.
Where is a single ground for fraud?
Lordship, when we have made the argument before this.
I'm not
court,
concerned with
because the
arguments.
charge sheet was filed.
Mr. Petitioner in
Yes,
person,
yes.
you are appearing without the help of a counsel. I'll presume that you know the law. Section 34 categorically mentions that arbitration award can be set within the precincts of the provision.
Yes, your lordship.
Now, fraud question you have not alleged in your petition under section 34, or you have also raised in your written statement or your statement of claim.
No, your lordship. It had been raised, your lordship,
No.
even in the arbitration award. We
No,
have just wait,
no.
your lordship.
Nothing doing. Anything else you have to say?
Yes, yes. Your lordship, yes.
Argue on the point of substantive law,
Your lordship,
having ignored.
your lordship, one para in the award, page 64, the fraud have been pointed out, your lordship.
Page
64 of the petition. Page 64 of my petition, your lordship.
what is that?
Yes. Page 64, point
These are
number,
your arguments.
yes. This is the
Arguments
award
cannot have
portion,
anything
your
to
lordship.
do with the reply.
This has
No,
been
nothing doing.
incorporated in the award, your lordship. I am reading the award. This is the second award, your lordship. This is the second award, your lordship. And I am just reading the point number J. The respondent also stated that while Mrs. Swapna Rani Paul is their authorized person, a relationship established through an agreement which read likes that an agreement between the broker and sub-broker. They do not have any relation with Mr. Swarup Paul. They raised a question again, which sounds like if Swarup Paul had been identified to be at the root of all the troubles, the appellant should have initiated criminal action against him. And they ascribed the reason for his not doing so. What was that both the appellant and Swarup Paul might have hands in glove, your lordship. So we have pointed out, your lordship, before the
That is
tribunal
not sufficient.
that anyway, your lordship, we have mentioned 12 ground, your lordship. So out of 12, fraud ground is one of the ground in the written argument, that is in your lordship on point number 8.
I am not going to hear on
Okay.
that ground.
So your lordship, in the written submission, your lordship,
Forget about the written submission.
additional submission, your lordship,
Nothing doing.
in
Come
the,
to the point.
yes, in the
You
additional,
are therefore to say, submit
yes, yes,
on
your
the
lordship.
ground that it is against the public policy.
Yes, your lordship.
Now, if it is against the public policy out there,
Yes, yes, that
not
goes
on the
to
ground of fraud, if it is against the public policy, the well substantive law of the land have been ignored. That is your ground
yes,
on which you have to argue. Nothing more, nothing less.
yes, your lordship. So your lordship, our submission is that this award is against the law of substantive law of the land. The one ground is that, your lordship, the transaction has taken place in July 2012 to March 13, your lordship. At that time, there were no concept in the market of maintaining the voice recording of the order. Your lordship, as far as this digital court has started, your lordship, this concept has started after 20, your lordship. And we are not aware that whether this entire record will be kept up to 8 years or not. So these concepts were not there in 2012, your lordship. The discussion had started in 2013. And the
That is again nothing to do with the substantive position. of-
we have because
No,
your lordship,
nothing
your
doing-
lordship,
Nothing,
page 68,
no.
your lordship, we have argued last time and it was
You
noted, your
argue
lordship.
whatever may be, but I'm today telling you,
Yes.
you have to only argue on the particular substantive position of.
Yes, yes, your lordship. Yes, your
Don't
lordship.
come up and beat around the bush.
Yes, yes, your lordship. That law itself has come in 2018 that you have to maintain the proof of placement of order. But the Honorable Tribunal had stated us that you should maintain the proof of placement of order in 2012. The law which was not there in 2012, the law itself has come in 2018, your lordship. Then how they have passed the order on the basis of that? I draw the attention, your lordship, page number 68 of the arbitration award. Page number 68, your lordship.
Yes.
Last para, your lordship, 6.4. With respect to the trades transaction in the FNO and currency derivative segment, the question about signing or ticking the relevant boxes in the KYC is only peripheral. The moot point is whether the appellant placed the relative order in the pre-trade stage. The respondent could not produce any evidence for this, your lordship. So the market practice is that, your lordship, once the order is placed, in the evening, the SMS is flashed that this transaction has taken place. This is the debit balance. This is the credit balance. Now, your lordship, NSE sends the message and the CDSL sends the message. 3 persons sends the message, your lordship. Then, your lordship, we sends the contract notes. Then, your lordship, we sends the ledgers. Then the depository ledger. Your
Again, you are coming to the facts.
No, your lordship,
You,
your lordship.
no, mister.
Yes.
Kindly don't spoil the time.
No.
I have the habit of, there is one judge in
That's
Bombay
why-
High
that's
Court
why-
who had made 5 crores as the limit by making the cost during his tenure. I want to supersede that. So remember, this is the cost I'm going to impose. Kindly come to the point.
So, So your,
You say that this law was not there.
yes,
Show me that.
yes.
Don't
Your
come up
lordship,
beat around this.
additional submission page number 130. your
No. Where the arbitral tribunal have taken that aspect, a law which was not there has been taken into account.
Yes.
Show me that.
So your lordship, additional submission page number 130. Your lordship.
Again, where in the arbitral tribunal he has taken into account that aspect of the matter. Your submission is the arbitral tribunal had taken into consideration a law which was not in existence at the time when the transaction was
Yes, it is in the page 64, your lordship. The moot point is whether page 6.4, page number 68, para number 6.4, third line, your lordship. The moot point is whether the appellant placed the relative order in the pre-trade stage. The respondent could not produce any evidence for this. So, and then your lordship, kindly see our additional affidavit, page number 130. This law has come in 2018, your
Which
lordship.
law?
Yes, I'm just reading.
That there was a requirement for placing relative order in the
Yes.
pre-trade stage.
This has come in 2018.
Where is that? Where is that law?
Page 130, your lordship, of our additional submission. Additional affidavit.
Yes.
Para number 3, your lordship, point number 3, to further strengthen the regulatory provision against the unauthorized trades and also to harmonize the requirement across the market, it has now been decided that all the brokers shall execute trades of the client only after keeping evidence of the client placing such order, which could be inter alia in the form of physical records, telephonic, email, log, this. When a dispute arises, the broker shall produce the above mentioned record for the
So
trade.
are you saying that prior to this, there was no requirement?
Yes, there was no
Sir,
requirement.
can you flip to page number?
Yes. 128, your lordship, it is written. Page 128, your lordship.
Yes.
Point number 2. The current regulatory requirement in commodity derivative market requires that the member shall execute the trade of the client only after taking the evidence of the client placing such order. Commodity में पहले से requirement थी, your lordship. It could be inter alia in the form of sound recording. There are no such requirements in equity derivative and currency derivative market, your lordship. So, in the currency market, this is the dispute of the currency market, lordship. This is the substantive circular, your lordship, of September 26, 2017. So, your lordship, there was no such law. So, this is against the law of the land, your lordship, and this is the root cause of wrong understanding of the matter, your lordship, which has set the entire, the entire award has gone in a negative direction, your lordship. So that is the material error which has been committed. Second, your lordship,
But what is number 3 at page 128?
is 128, number 3. Yes, your lordship, they are telling that now onwards, they have stated that you have maintained the proof of placement of order. And then says, when dispute arises, the burden of proof will be on the broker to produce the above records for the disputed trades. Now, your lordship, then what happened? This circular shall be effective from 1st of January 2018. It is written in point number 5, page 129. Now, your lordship, again, it has gone in the market for the observation, and then the circular of this 130 March 2028 has come. And then, your lordship, again.
Now, wait.
Yes.
Did you place this circular before the arbitral tribunal?
No, this circular has come in 18, your lordship. This
So when was the judgment delivered?
in December 14, your lordship, July 14. This order is of July 14, your lordship. This
So at that point of time, what was the circular prevailing?
yes. There was no such requirement, your lordship. Just I'm drawing the attention, your lordship. Your lordship, I can draw the attention on the page number 104. The settled award, there is 3 award, your lordship. One award is of Prem Lata Khemani, which is a well settled, which has not been challenged, your lordship. I like to draw attention on 104 of the petition, which describes the entire concept, your lordship, and this award has not been challenged. This is the appellate award of 3 members. Page 104. Can I read your lordship? Yes. Having regard to the above principle of judicial inquiry, we would like to record that in the matter of determining whether a trading has done with the consent or not, one need to follow the regulation made in this regard by the exchange. There is no denying the fact that the regulator has prescribed that conform order only should be executed one, but when it has also laid down that trading is a process which begins with the placement of order, followed by confirmation, followed by sending the SMS alert, and lastly by issuing the contract notes which are to be issued within 24 hours of the trading day. And on receipt of the said contract note, the client is given opportunity to raise the objection, if any, to any of the trades, failing which it would be presumed that the contract is complete. We find that the learned sole arbitrator has aid to see that the respondent has admitted to have received the SMS alert. The appellant has also...
In this case,
This was the same case, your
no. Here the respondent has admitted to have received the SMS alert.
Yes.
In this case, has he also admitted?
Yes. More than, yes, your lordship. I like to draw attention, your lordship.
The appellant has also furnished the SMS log in the form of its chain,
Yes, your
and
lordship.
that the respondent has
Page
admitted
45
to have
of the
received
petition.
4 or 5 contract notes by post. So did you prove
Yes.
before the arbitral tribunal
Yes.
that have admitted that the appellant have also furnished the SMS log? Did you
Yes,
prove it?
Yes. That's
Where?
why the first award was in favor, page 45. Page 45 of the petition, your lordship. Page 45, your lordship.
Yes.
Point number J. This is the respondent has sent, this is the first award details, your lordship. The respondent has his contract notes digitally 83 times. Contract notes in physical mode, more than 5 contract notes produced by the opposite party. Balance concealed by him. Proof of dispatch of the entire contract notes in physical mode through bulk India Post is enclosed and available on record. हमने सारे, we have sent in the physical contract notes, we have produced all record. Denial of more than 383 digital contract notes and relying on only one mail of AP clearly established the contradictory statement of the applicant. And SMS mobile number 58 times. Transaction ledger of DP. Applicant has enclosed the following documents which speaks volume about this, your lordship. And your lordship, the final conclusion which the honorable arbitrator had stated, your lordship, page 51 is very important. One para only, page 51. Page 51, got your lordship? Point number G. Yes. Page
Point number
51.
G.
Point number G.
Last 4 lines.
Last 2 lines.
Applicant's admissibility that nothing was delivered to him and received by him does not seem to be practical.
Yes.
Whereas in this case, the appellant have duly admitted that he has received the SMS.
Yes.
That is the difference.
Yes. Page 43, your lordship, he has admitted. Page 43.
No, here he has denied. Where?
Please see 43, your lordship, page 43. Middle para. The applicant submitted in his arbitration application that he received few SMS in his mobile in the month of September 2012. With respect to the trades in currency segment, your lordship, they have admitted that the mobile number is not in dispute, your lordship. And your lordship, the entire things are system driven, your lordship. There is no manual control, your lordship. We have produced the entire logs of that, your lordship, which has been truly entire evidence have been produced, which has been recorded in point number 3, your lordship.
Okay, take your seat. Yes, Mr. Samari.
My lord,
Isn't it a case of perversity?
my lord, so far the element of fraud is concerned. my lord.
Forget about the fraud. We are not concerned with the fraud.
My lord.
But here is a case. Isn't it a case of perversity? Taking into account that these SMS logs were duly received by the applicant in here, where he have duly stated that I have received the SMS. And there is another person who says that these are erroneous. So isn't it a case of perversity which the learned first appellate, the 34 court ought to have looked into?
So the only
And perversity is a question
for
of,
the, if we center to the issue of only SMS, my lord, or if we center ourselves only the issue of SMS, my lord, which has been received by that person's concern, my lord. Now, my lord, it is a matter of proof, my lord. It is there only a statement.
is it not, this is not a statement. The applicant submitted in his arbitration application
Yes, my lord.
that you have received SMS.
My lord, this is the stand taken by them.
No, this is your stand. Kindly see at page 43.
Yes, 43. Paragraph 1.
Ah,
Proceed which one to
paragraph, the second paragraph.
second. The applicant submitted in his arbitration application that he received few SMS in his mobile in the month of September 2012 with respect to trade in currency segment. But whenever he asked the said AP about those transactions, he always assured him sometimes by saying that this was erroneous transaction, wrongly executed in his case, and he will take care of the same of sometimes by saying that SMS was sent wrongly and he should not worry about the same. The applicant also submitted that in the month of November 2012, when he started sensing serious wrongdoing in his account, he requested the AP to provide with transaction detail in his demat holding, and after avoiding it initially, the AP provided him a bunch of documents, and on scrutiny of the document, he realized that the massive trades were done in his account without his consent. The applicant denied receipt of any contract note or any account statement or mail from the respondent during the period of time. Well, these are all disputed facts, my lord.
No, but you have received the SMS.
But SMS, suppose this says that I have received SMS, but thereafter it has been, my lord, in regard to verification, my lord, it was a call for them. Then they said that it is wrongly.
No, somebody else.
Understood, but
Somebody else have stated to you that these are wrongly sent by
Yes,
them.
yes.
But the fact that the appellant herein have duly sent it
yes,
is not in proof or not in doubt.
yes, this paragraph.
And
shows
if that is so,
Well.
why did the arbitration tribunal
Well.
categorically hold that there is no proof?
Well, proof in
Isn't it
regard
a
to,
case
my
of
lord,
perversity?
but it requires authenticity, my lord. Suppose SMS,
Authenticity is an admitted
but
fact.
SMS is not sufficient, my lord. The reason is that, my lord, SMS, suppose the transaction has been suppose done. Now, SMS normally that has been sent. Now, once it has been done and sent, then, my lord, it because I put a question that there is a doubt that this transaction may not belongs to me. Therefore, I questions to the concerned person. He said it is wrongly suppose sent, or it would be.
Did you ask the appellant?
Pardon?
Did you ask the appellant?
But this is clearly says, this
Appellant. Because they, from their side, they've sent it. You see, the burden now is on the appellant.
exactly, my lord.
But the appellant have discharged the burden and saying that, look here, we have sent you the SMS as regards these things.
Correct.
And under such circumstances, you are to object. If you have any objection, you should have placed the objection. Did you raise any objection?
My lord, objection we have raised. Reason is that, my
When?
lord, because the middle person which is acting on their behalf, my lord, because we have do not direct accessibility to the, my lord, it's a big company, suppose. Then what is the nearest approach to the made by the concerned investor, to the person with whom we are dealing, who is like an agent acting on their behalf? It is not a case, suppose we can approach direct to the company, my lord. It is not such a measures which is otherwise possible. Because the transaction which has been committed between investor and the agent, my lord, this is the normal practice that has been adopted. But question is that, my lord, we are dealing with 37, my lord. They are raising so many issues which is otherwise may not be the purview of, my lord, 37.
No, we are, therefore I said that fraud
Yes,
and
my
all
lord.
these things go.
My lord,
But the fact that there, you see, the basic reason
Let it be
is they failed to prove that you have been duly intimated. Now, it is a question, is it a case of perversity where the learned arbitral tribunal have committed by opining out here at paragraph number, where is that? 6.4. Paragraph 6.8, page 68.
my lord.
With respect to the trades transacted in the FAO and the currency derivative segment, the question about signing or ticking the relevant box in a year is only peripheral. The moot question is whether the appellant placed the relative borders in the pre-trade sale. The respondent could not produce any evidence for this. More importantly, clause 4.1.a of the amendment so and so requires the TM to provide the constituent with a copy of the trade confirmation slip on the trading system and a positive averment made in 9.8 18.2 of the member client agreement reading as the client shall not be entitled to presume an order have been executed, cancelled, or until a confirmation from the member is received by the client.
Client.
The appellant did not receive any confirmation at the post-stage trade in respect to any of these trades in question. The respondent failed to produce any proof of the trade confirmation slip dispatched to the appellant. Absent this, in view of the denial of the appellant that the order was placed, it is difficult to establish that the trades were executed with the
their
consent. Further, this also militates against the respondent's contention that all closed liquidations rollover orders were in accordance with the instructions of the appellant. There is also no evidence to show that the respondent ever made a demand for margin shortfall anytime and thus complied with the requirement under so and so. The above discourse would bring to focus the unfavorable impact of the case has caused to the appellant to confirm the rules. The respondent felt that their task over by mailing the documents to the appellant which were not received by him by genuine reasons for considerable period
Period of time.
have also become a stickler. Now, what was the applicable law at that point of time? Where is this NSEIL regulation? Where is that?
This, your lordship, that's I'm showing your lordship. The arbitrator,
Don't come to all these things. Don't beat around the bush. Again, I'm saying.
again.
Where is this NSEIL regulation?
4.11, yes, sir.
Where is it?
SMS followed by, my lord, there are so many formalities which they free to do so.
4.11, your lordship, page 84.
Page
84. Your lordship, what they have done, they have quoted the half of the portion of the law. That is the error which has been done by the Honorable Tribunal. The law says the trading member shall provide constituent with a copy of the trade confirmation slip as generated on the trading system.
4.11.
4.11.
Yes, read to 4.411. The trading member shall provide constituent with a copy of the trade confirmation slip as generated on the trading system forthwith on execution of the trade and if so desired by the constituent and with a contract note for the trade executed. No. And if so desired by the
Desired by-
constituent, then with a contract note.
They have not desired your lordship. So the
Sir.
Honorable Tribunal. I
No,
just-
no. The trading member shall provide the constituent with a copy of the trade confirmation slip as generated on the trading system forthwith on execution of the trade. Then
Yes.
they put a comma.
Yes.
If so desired by the constitution with a contract note for the trade execution.
Yes. So your lordship,
So if he does not desire, you need not give that contract note for the trade. But you have to give
Confirm.
the confirmation slip.
so your lordship,
Yes.
your lordship, contract notes is mandatory in the stock market. The
Where
confirmation-
did you give the
Page 86,
no
your lordship.
confirmation? Where did you give the confirmation? You must be having a copy of the confirmation,
Page 86. your lordship.
Mr.
I'm
Counsel.
showing
Did
you the
you?
same thing, your lordship.
Yes. Where?
Page 86.
What is that?
Your lordship, on the lower part, there is a term and conditions, right? Upper part, 2 lines upper, we also authorize you not to provide the order confirmation, modification or cancellation slip or trade confirmation slip to avoid unnecessary paperwork. We hereby authorize you to send the periodic statements. We shall get the required details from the contract notes issued to us. They have given the authority and this letter is voluntarily your
So
lordship.
you mean to say that
Yes.
you did not give the confirmation slip?
Yes, it is not required.
No, you did not give.
We have not given trade confirmation.
Fantastic. Now, whether this document at page 86 was a part of the documents placed before the arbitrator,
Yes, your lordship.
where will you get the arbitration? Yeah?
This is the KYC documents, your lordship, and this entire record was placed before the tribunal, your lordship. We have placed that documents, your lordship. So this is the part of the agreement, your lordship, that contract notes, your lordship, with exhaustive documents. Trade confirmation slip, like as your lordship, on the terminal, the
No, where did you get this page 86?
page 86 is from the KYC documents, your lordship. The entire records was there in the before the tribunal, your lordship. They have only written half, your lordship. What they have done, they have written 4.41 का आधा portion उन्होंने लिखा. They have written half of the portion. If so desired by the constituent, they have not written.
No, if so desired by the constituent with a contract note for trade executed.
Additionally, यदि contract beside
But
contract,
otherwise, the other thing is compulsory for you to give.
yes, your
Otherwise,
lordship.
there will be a lot of fraud.
Yes, your lordship. We have given the contract.
Anyways, I think this is a fit case for dismissal.
No, your lordship,
Enough.
this is the, your lordship.
Dismissal.
There are other points, your lordship.
No more points. We
Your
are not
lordship,
going
page-
to,
once your lordship-
37, this court is not going to.
No,
fight.
your lordship, page, I'm just showing you.
Where is the confirmation slip you have not given? Matter ends.
Confirmation slip, your lordship, it was not mandatory. What is the law? Your lordship, I'm again reading.
You, I think the better is the Supreme Court will decide. Look, okay.
No, your lordship,
Therefore-
your lordship,
This is
this
an
court
appeal.
is, this court is
Okay,
everything-
Mr. Counsel, take your seat. Enough. I've heard you too much. Take your seat. Dismiss.
Your lordship, 2 more points, your
No more points. Enough of your points.
Your lordship, एक पैरा हम पढ़ा देते हैं, lordship. After then I will be sit, your lordship. I will not speak a single line, your lordship.
Okay, where?
Page 43, your lordship. The second last para, your lordship. The applicant submitted that. Yes. एक minute. The applicant further submitted that he did not receive any electronic contract notes, as the email ID provided to him by this was not assessed at all. He received few SMS from the broker and some margin statement in his email ID at the khemani@red.com. Your lordship, July 2012 to March 2013, the transaction has taken place. On 6th of September, this new email ID has come. So only 1.5 months, this email ID was there. 6 September to March 2012, this email ID was there, your lordship. So it admitted that some margin statement in
Mr. It is 9%.
it. Now,
This is not a court to decide all these things. That is none of my business. 37 court does not look into all these things. Here is the fact is clear that you did not give the confirmation slip. Matter ends. Heard. Instant appeal. An appeal under section 37 of the Arbitration and Conciliation Act, challenging the order dated 25/10/2017, passed in Mizze case number 109/2017, whereby the learned district judge Tinsukia had rejected the application Where is the main order?
It contained in page below the
That's a, oh yeah, whereby challenging the order dated 14/8/2017, passed in Mizze case number 149/2014, whereby the application filed under section 34 of the Arbitration and of the Agote Likhi Dibo na, Act of 1996, of the Act of 1996 was dismissed. This court, before embarking on adjudicating the instant appeal, would like to observe that, taking into account the well-settled principles of law by the Supreme Court in the case of ULS. What is that? Huh?
Can I give your lordship judgment last one?
Yes, my judgment that is,
Yes.
it is there.
This is
Case of,
lordship, this is the book.
I referred there.
Yes, yes. And the other also there.
In the case of UHL, Power Company Limited versus State of Himachal Pradesh, reported in 2022 4 SCC 116. The scope of an appeal under Section 37 of the Act of 1996 is more circumscribed than the jurisdiction of a court exercising powers under Section 34 of the Act of 1996. In the backdrop of the above, let the state court take note of the brief facts leading to the filing of the instant appeal. The respondent number 1 herein had opened a trading and demat account with the appellant company. Company or what?
They're not the company, they are company.
Yes, sir.
Appellant company. Through the executing member-client, by executing a member-client agreement. On the basis thereof, the applicant, the respondent number 1 was given a unique client code being CXO0075. For a period of 2 years thereafter, the respondent number 1 sold some shares on 12/7/2012 and submitted delivery instruction slip to the DP. What is DP? That is the Stock Holding Corporation of India Limited against the pay in obligation of the shares. It has also been mentioned that the respondent number 1 had opened a trading and demat account with the appellant company through its authorized person (AP) one Swapna Rani Paul. However, the business of the said authorized person was looked after by her son, one Sorup Paul. It is the further case of the respondent number 1 that he applied for initial public offer of Coal India Limited through the appellant company in October 2010, and he was allotted 100 shares of Coal India Limited, which was lying in his demat account with the appellant company. The authorized person, it was alleged that the authorized person requested the appellant, the respondent number 1, to transfer his earlier investments, which were lying with the Stock Holding Corporation, in the demat account with the appellant company, and the respondent number one agreed to transfer the same as he found no sense in maintaining two separate demat accounts. Full stop. The authorized person thereafter sold all the shares through the appellant company and bought back the same so that the shares were moved to the appellant's demat account maintained with the appellant company. Full stop. It was alleged that after the stocks were transferred to the appellant company, the authorized person started massive and erratic trading, mainly in currency derivatives and equity derivatives segments. That too without the consent of the respondent number one. Full stop. In view of the actions on the part of the authorized person who made unauthorized trades, there were huge losses. And the authorized person, in order to make good the said losses, sold the existing stock of the respondent number one in the month of August 2012, and that too without his consent. The respondent number one, sensing the wrongdoings in the month of November 2000, in the first week of November 2012, requested the authorized person to provide his transaction details and holding statement, which was, however, not provided. In spite of various requests. The respondent number one thereupon inquired in the office of the appellant company situated at Kolkata and Delhi about his holdings, and was shocked to learn that majority of his investments have been wiped out due to huge trading losses, and they sent him the relevant documents showing the transactions since July 2012. As per the respondent number one, the said transactions occurred sometime in the month of July 2012 to December 2012. The respondent number one thereupon approached the authorized person, who assured that the losses so suffered by the respondent number one would be made good. However, the respondent number one, sensing that there were certain fraudulent and unauthorized trading activities in his account, lodged a complaint before the appellant company on 5/4/2013, as well as the NSE Investor Grievance Cell on 22/4/2013. In response to the complaint so filed to the appellant company, the said company defended the actions of the authorized persons and dismissed the complaint, stating that all the transactions were done knowing with the due notice, with the due knowledge of the respondent number one. It is under such circumstances the arbitration proceedings were initiated. Full stop. Pursuant to the said arbitration proceedings being filed, the appellant company submitted their defense, stating inter alia that the petitioner was provided the appellant company submitted its defense, stating inter alia that the respondent number one had due notice of all the transactions, inasmuch as the appellant company duly informed the respondent number one through SMS as well as through contract notes. Pursuant to the evidence which was standard before the arbitration tribunal, the arbitration tribunal provided an award dated 6th of March 2014, rejected the claim of the respondent number one, holding inter alia that there is no sum to be payable to the respondent by the appellant company to the respondent number one. The the appellant company also had filed a counterclaim which was dismissed. Being aggrieved, in terms with the being aggrieved, taking into account that the arbitration proceedings, the arbitration clause stipulated an appellate forum against the order passed by the original arbitrator. An appeal was preferred by the appellant, by the respondent number one, before the appellate forum, appellate arbitration forum. The appellate arbitration forum passed the appellate arbitration award on 25/7/2014, holding inter alia that the award which was passed by the original arbitrator is bad in law and accordingly liable to be set aside. And the respondent number one herein would be entitled to an amount of rupees 4,50,000 from the appellant company for unduly selling his shares.
Your Lordship,
It is, don't disturb, take your seat. It is seen that the learned appellate arbitration tribunal decided the arbitration proceedings in favor of the respondent number one, primarily on the ground that there was no compliance by the appellant company to clause 4.4.11 of the NSEIL regulation bracket FNO segment, which required the appellant company to provide the constituent with a copy of the trade confirmation slip generated on the trading system. It was also observed by the appellate arbitral tribunal that the respondent number 1 herein did not receive any confirmation at the post-trade stage in respect of any of these trades in question. The appellant company further failed to produce any proof by way of trade confirmation slips dispatched to the appellant to the respondent number 1. And under such circumstances, the learned first appellate arbitration tribunal came to a categorical opinion that it was that it is difficult to hold that the trades were executed with the consent of the respondent number 1. In addition to that, the appellate arbitral tribunal also held that the case set out by the appellant herein, that all closeout oblique liquidation oblique rollover orders were in accordance with the instruction of the respondent number 1 herein cannot be believed, as there was no evidence to show that the appellant company herein ever made a demand for margin shortfall of oblique any time, and thus complied with the requirements contained in clause 3.10 bracket small a and 3.10 small b of the said regulations. Justo. The appellate arbitral tribunal also held that the respondent number 1 also had his share of blame, inasmuch as the respondent number 1 should have advised the appellant company on receipt of the authorization form through the welcome kit that the pre-printed email ID was not his, and that he did not want a fresh ID through a third party. However, the appellate arbitral tribunal came to an opinion that investors are considered gullible always for such action. and accordingly reduce the compensation from rupees 5 lakh to 4,50,000. In addition to that, the Appellate Arbitral Tribunal also directed corporate payment of rupees 6,192 subject to production of original information materials from each of the concerned entities. Being aggrieved, an appeal, a proceedings under Section 34 of the Act of 1996 was filed before the learned district judge, Tinsukia. Although the application filed under Section 34 of the Act of 1996 is not placed on record. But however, during the course of the hearing, a copy thereof was submitted before this court. This court have duly perused the said application filed under Section 34. The learned district judge, by the impugned order dated 14/8/2017, dismissed the application on the ground that it was not a fit case for interference under Section 34 of the Act of 1996. On the question of fraud, which was argued only during the course of the arguments, but not a part of either the pleadings before the arbitral tribunal or in the application under Section 34. The learned district judge opined that the said aspect could not be taken into account, that the fraud element was brought to within the fold of Section 34 only by the Arbitration and Conciliation Amendment Act 2015. Being aggrieved with the rejection of the application under Section 34, the instant appeal had been filed under Section 37. I've heard the learned counsel appearing on behalf of the learned petitioner in person, who is duly authorized by the appellant company. The petitioner in person submits that the learned district judge, while rejecting the application under Section 34 of the Act of 96, completely erred in law in not taking into account the question of fraud. The learned petitioner in person submitted that though the element of fraud was brought in specifically by the Arbitration and Conciliation Act Amendment Act 2015, but fraud vitiates all proceedings, and under such circumstances, the learned district judge could not have rejected the submissions on as regards fraud. The learned counsel, the learned petitioner in person, in addition to that, submitted that in terms with Section 34 of the Act of 1996, interference with an arbitral award is permissible if the if the award so passed is in conflict with the public policy of India. He submitted that the question of giving due information and obtaining the consent only came into vogue on the basis of the circular issued by the Securities and Exchange Board of India dated 26/9/2017, which came into effect with effect from 1st of January 2018. The question of obtaining a consent was not necessary at that relevant point of time. And the learned first arbitral and the first and the appellate arbitral tribunal grossly committed a perversity in allowing the claim of the respondent number one on the ground of not taking a consent, which was not the law prevalent at that point of time.
Of placement of order, you lost, not consent. Of order, not consent. Consent के बिना तो कुछ कर ही नहीं जा सकता ना. Proof of placement of order was not required. Maintenance of proof of placement of order was not required before it.
Proof of placement of order was not required. Consent only. He further submitted that a perusal of the circular dated 26/9/2017 categorically shows that the requirement of physical record written and signed by the client, telephone recording, email from authorized email, log from internet transactions, record of SMS messages, and any other legally verifiable record only was made a requirement post the circular dated 26/9/2017. Further, the learned petitioner in person submitted that the learned first appellate tribunal, the appellate arbitration tribunal did not construe clause 4.4.11 in the proper manner and have only taken into account the first portion of the said clause and thereby omitting to take note of the second portion. He submitted that the learned first arbitration appellate tribunal had only stated that a trading member shall provide the constituent with a copy of the trade confirmation slip as generated on the trading system forthwith on execution of the trade, but failed to take into consideration that the said requirement was only necessary if it was so desired by the constituent. Full stop. Referring to the KYC application, which was at page 86 of the appeal memo, the learned counsel, the learned petitioner in person submitted that the respondent number 1 had duly waived his right to receive the trade confirmation slips to avoid unnecessary paperwork. On the other hand, Mr. The learned the petitioner in person therefore submitted that these were vital aspects of the matter which touches on the perversity in the judgment or in the award passed by the appellate arbitration tribunal. And this aspect of the matter ought to have been taken into consideration by the learned district judge while deciding the application under section 34, for which the said order dated 14/8/2017 requires an interference. On the other hand, Mr. S. Samaria, the learned counsel appearing on behalf of the petitioner, respondent number 1 submitted that the interference to that the scope of our proceedings under section 37 is far more circumscribed than our proceedings under section 34 of the Act of 1996. Referring to the judgment of the Supreme Court in the case of Associate Builders versus DDA, reported in 2015 3 SEC 49, the learned counsel submitted that an award could be set aside if it is contrary to a fundamental policy of Indian law, or B, the interest of India, or C, justice or morality, or D. In addition, if it is patently illegal. He further submitted that the illegality has to go to the root of the matter. And if the illegality is a trivial nature, it cannot be held that the award is against public policy. Further putting reference to the said judgment in associate builders, the learned counsel submitted that the award could be set aside if it is so unfair and unreasonable that it shocks the conscience of the court. Such award is opposed to public policy and is required to be adjudged void. The learned counsel further relied upon recent judgment of the Supreme Court in the case of S.V. Samudram. Reported versus State of Karnataka, reported in 2024, PSCC, page 623. And submitted. And placed reliance on the paragraphs 26 to 30. He further submitted that the merits of an award are only to be gone into if the award is demonstrated to be contrary to public policy of India. And further submitted that, as held by the Supreme Court in the case of associate builders, the concept of public policy connotes some matter which concerns public good and the public interest. He therefore submitted that what is for public good or in public interest and what would be injurious or harmful to public good or public interest has varied from time to time. However, the award, which is on the face of it patently in violation of the statutory provisions, cannot be said to be in public interest. The legal counsel further submitted that that though the petitioner in person have raised the issue of fraud, but there is no element of fraud alleged in the written statement, in the statement of defense, or even in the proceedings before the appellate appellate arbitration tribunals. Even a perusal of the application under 34 of the Act of 1996 filed by the appellant company would also show that there is no allegation of fraud. The fraud element is sought to be brought in only for the first time during the course of hearing under Section 34 of the Act of 1996. He therefore submitted that a question of the element of fraud have been rightly rejected by the learned district judge in passing the impugned order. The learned counsel further, referring to clause 4.4.11, which was the basis on which the learned first appellate arbitration tribunal had passed the award, submitted that the remaining portion of the said clause, that is inverted comma, if so desired by the constituent, would only be applicable with regard to the contract note for the trade executed. However, for the purpose of providing of a copy of the trade confirmation slip, the same has to be provided to the trading member. Sit down. It is his submission. Isn't that your submission? Anything else?
A small issue, Lordship, consider not Lordship limitation part is also there, Lordship, because
What limitation?
one of the application which they filed under Section 37 exceeded.
Oh, that has been taken care of by the Supreme Court in a recent judgment.
Yes, that is one of the ground, my lord, because sometimes what happened, my lord, the 37 one was invoked, my lord.
No, but the Supreme Court recently have taken over. They say that the same 120 days would not apply in 37.
My lord.
So nothing there. Anything else?
No. Only one thing is that only one I would like to add, my lord, because of their, my lord, high-handedness, my lord, I have to face jail, my lord. But then also, my lord, I have to run from pillar to post to fight my rights, my lord. Lordship cost may be imposed in my lord.
How much?
Because my lord, I am also going to get the interest. my
No,
lord.
interest you have not got. If we put the same amount as interest, cost,
My lord,
4.5
I leave to your
lakhs.
lordship and consideration. It required, my lord. It's a very serious, my lord. Unnecessary, I have been put in jail.
Yes, what do you have to say?
Lordship, this is the court of justice, and to Lordship, Supreme Court is there. But again, that's a consuming time. For me, your Lordship, this is the court where we can get the, your Lordship, 4 or 5 minutes can change the fate of this case, your Lordship. In this country, the statement which is written that no one can say that without contract notes, any transaction can happen. So, your Lordship, contract notes, we have sent it digitally, physically, and everything. So, your Lordship, no one even
No, this is
signed.
not-
I asked,
Physically,
Mr. Counsel, I asked you a specific question. Did you give the trade confirmation slip?
trade confirmation.
You
slip
did
we
not.
have not given your Lordship.
Matter ends there.
It is waived off by them, your Lordship. Contract notes contain entire information, your Lordship. That's why I'm telling. The law says, your Lordship, read 4.4.1 again, your Lordship.
No.
Why the Supreme Court will read your Lordship? Your
He
Lordship
should be
can read your
restrained, my lord.
Lordship.
He should
That
be
says,
restrained, my lord. At the time of
that-
judgment, if he argues this way, my lord, this is really breach of the discipline, my
no,
lord.
no, your
No,
Lordship.
no, he cannot do.
Your
He's
Lordship,
a-
it is the
He's a
submission,
learned
your
person. He
Lordship.
should know that once
It is the
writing is going
submission,
on, my
your
lord.
Lordship.
He should not argue this kind of thing, my lord.
4.4.1,
It's a
your
matter of
Lordship, it
decorum, my
says
lord.
that
Lordship,
the
because
signed
Lordship will-
contract notes that
Because
can be
Lordship
there.
is lenient, it doesn't mean that they
No,
can take
no,
advantage
your
of the
Lordship.
situation. We know
And
that Lordship,
This entire award is by assumption, presumption, your
what
Lordship.
practice you
And
are
based
following
on
here?
that thing, your Lordship.
The judgment is writing and you are now again
And your
arguing.
lordship, the case of fraud, I like to point out one judgment, one para, your lordship, this is of
Better to
2023.
Impose a heavy cost for you
No.
because of breach of this discipline.
We have to.
Yes,
This
what
practice is going
judgment you?
someone else,
One
not in this
judgment
court.
I'm showing your lordship.
Your practice is going someone else, not in
Yes.
this court.
Yes.
Don't follow this kind of thing here.
Yes, where?
No, lordship, lending it, that doesn't mean that you take advantage of
Ask
the
your lordship, if courts find that,
What? Delhi High Court?
no, your lordship, the Supreme Court quotation, your lordship,
Where?
that part is the Supreme Court quotation.
Which judgment?
In that, your lordship. Say that if the court finds that.
You
so-
will be very, it will be very easy for you to get it. Anyways, this may help you to dismiss your petition more.
Lordship,
Let me come back and
your lordship, I will take 2 minutes. Page 84. Point number 4.4.11. I read your lordship. I'm just reading your lordship. The trading member shall the trading member shall provide constituent with a copy of the trade confirmation slip as generated on the trading system forthwith on execution of the trade, if so desired by the constituent, and with a contract note for the trade executed. Means with a contract note, trade execution slip is additional document that should be given if the client is asking for that. In the Indian stock market, no one can waive the contract notes even by executing the agreement, your lordship. So this law says, कि ये करना है. Then your lordship, page 86. Page 86, now I read the whole para, point number 8. That will clear everything, your lordship. Page 86, point number 8. May I read your lordship? May I read your lordship? तो छोटा है, आपको दिक्कत होगी. Authorization to issue contracts and contract notes, a statement of fund and security in digital format. We hereby agree and consent to accept the contract notes for the transaction carried on by me oblique us with you in forms of the agreement entered into between us in the digital form. Digital contract note issued by you as per the terms and conditions specified below shall be binding on me. We hereby undertake to check the contract notes.
I've heard the learned counsels, the petitioner in person, as well as the learned counsels appearing on behalf of the respondent. An additional affidavit was filed whereby the arbitration mechanism in stock exchange was brought on record. Arbitration mechanism under the National Stock Exchange of India Limited was brought on record. From a perusal of the state bylaws, which was bylaws of the National Stock Exchange of India Limited, and more particularly Chapter 11, is seen as to how the arbitration proceedings are to be carried out. It is in accordance with that, the present arbitration proceedings was initiated and culminated the present arbitration proceedings was decided. Before proceeding, one has this court also duly takes note of that the arbitrators who have decided the instant proceeding were well versed with the rules and regulations of the Security and Exchange Boards of India, as well as the National Stock Exchange of India Limited. They were specialized arbitrators taking into account that this court is taking up proceedings under Section 37 of the Act of 1996, and as already stated herein above, the power of interference is far limited than the power so conferred upon the court under Section 34 of the Act of 1996. It is also well settled that Section 34 of the Act of 1996 limits a challenge to an award only on the grounds provided therein or as interpreted by the various courts. The Supreme Court, in the case of Dyna Technologies P Limited versus Crompton Gibbs Limited, reported in 2019-20 SCC 1, categorically observed that arbitral award should not be interfered with a casual and a cavalier manner unless the court comes to a conclusion that the perversity of the award goes to the root of the matter without there being a possibility of an alternative interpretation which may sustain the arbitral award. It was observed that Section 34 cannot be approached in a similar manner as in the case of a normal appellate jurisdiction. The mandate under Section 34 of the Act of 96 is to respect the finality of the arbitral award and the party autonomy to get their dispute adjudicated by an alternative forum as provided under the law. If the courts were to interfere with the arbitral award in the usual course on factual aspects, then the commercial wisdom behind opting for alternate dispute resolution would stand frustrated. It is also seen that in various other judgments of the Supreme Court, it had been held that the court should not interfere with an award merely because an alternative view on facts and interpretation of the contract exists. The courts need to be cautious and should defer to view taken by the arbitral tribunal, even if the reasoning provided in the award is implied, unless such award portrays perversity unpardonable under Section 34 of the Act of 96. In the instant case, there are various contentions raised by the parties. The first contention so raised is as regards fraud. The first contention raised by the appellant company is as regards fraud. No doubt, fraud vitiates all proceedings. And as such, when there is a fraud committed, the arbitral tribunal has to take note of the said aspect of the matter and decide accordingly. However, for establishment of the element of fraud, there is the requirement of pleadings. And on the basis thereof, evidence has to be supplied. However, in the instant case, be that as it may, however, in the instant case, it would be seen that the allegation of fraud was never brought either during the arbitral stage or even in the application under Section 34. It was first time brought in by the written argument placed before the court dealing with the Section 34 application. This court is of the opinion that if a fraud is being alleged at a late stage and not before the arbitral tribunal, and if the court under 34 or the appellate court under 37 are to take note of those aspects of the matter, it would amount to reappreciation of the case in total, which is not a permissible mode in a proceedings under Section 34 or 37 of the Act of 1996. Under such circumstances, this court would not like to rejects the contention of fraud as submitted on behalf of the appellant company. The second submission which have been made by the petitioner in person is as regards the is to the fact that the learned first arbitration tribunal, appellate arbitration tribunal, have taken into consideration certain laws which were not in existence till 1/1/2018. This court, upon perusal of the arbitration award dated 25/7/2014, duly finds that the learned first, the appellate arbitration tribunal had decided the issue on the basis of clause 4.4.11 of the National Stock Exchange, what is IL, of India Limited regulation bracket FNO segment bracket close. The appellant company, though, tried to impress this court on the basis of the circulars dated 26/9/2017 and 22/3/2018, that the members shall execute the trade of clients only after keeping evidence of the client placing such order. And it was submitted that this aspect only came into being with effect from 1st of January 2018. But there is no material shown before this court as to what was the circular prevalent issued by the Security and Exchange Board of India during that relevant point of time in the year 2012, when the transaction had happened. Taking into consideration this circulars dated 26/9/2017 as well as 22/3/2018, that too at the appellate stage under section 37 would amount to taking into reappreciation of the case, which is again not permissible under law. The appellant company, the appellant company further urged that clause 4.4.111 of the National Stock Exchange NSEIL regulation FNQ state segment was not correctly interpreted by the learned arbitral tribunal. Stating inter alia, thereby submitting inter alia that Trade confirmation slips are only to be issued if desired by the constituent. And in the instant case, the constituent, by issuing a KYC form, by signing on the KYC form, had authorized the appellant company to not to provide the trade confirmation slip. The learned first, the first, the appellate arbitration tribunal had made and given an interpretation to clause 4.4.11, stating inter alia that the trade confirmation slip was necessary in terms with the said clause. This is an interpretation given by the arbitral tribunal. It is well settled that if there are two interpretations possible, and the arbitral tribunal had taken into account, given an interpretation which otherwise would not show there is patent perversity. The question of interference under Section 34 of the Act of 1996 does not arise. Under such circumstances, this court is not inclined to accept the said submission on behalf of the petitioner, on behalf of the appellant company. Consequently, this court finds no merit in the instant appeal, for which the appeal stands dismissed with cost of 25,000.
Deeply okay.
Lordship, this item number 5. Lordship, as told on the earlier occasion, item number 5, your Lordship, as told your Lordship, it may be upgraded, your Lordship.
No upgrades. Take it up when it is.
Supplementary item 12 to 17 and production list 1.
I have prepared a paper book in this case, Lordship.
Yes, Mr.
Lordship,
Jain.
Lordship, I yesterday raised certain queries whether the placing of the notification would suffice. I have requested my learned friend to just tender the compilation where the Honorable Supreme Court has said that just placing this notification will not do. My Lordship,
Yes,
the
what is that?
first case is Hukamchand versus Union of India. In this case, a notification was issued with a retrospective effect. It had a similar clause like the one in GST. It is at page 5, my lords.
Page?
Lordships. 5,
What
para
five?
7. Yeah.
No
Page
page
5.
number here. 7. Page number business. 5, yes.
Yes, para 7. The similar section 164. This also has a provision. Every rule made under this section shall be laid as soon as may be after it is made before each House of Parliament while it is in session for a period of 30 days, which may be comprised in one session or in 2 successive sessions. And if before the expiry of the session in which it is so laid or the session immediately following, both houses agree in making any modification in the rule, or both houses agree that the rule should not be made, the rule shall thereafter have effect only in such modified form or be of no effect, as the case may be. So, however, that any such modification or annulment shall be without prejudice to the validity of anything previously done under that act, under that rule. The findings by lordships at page 7, para 13. Is identical to section 164 under GST.
Para?
Para 13 starts from the last. The fact that the rules framed under the Act have to be laid before each House of Parliament would not confirm validity on a rule if it is made not in conformity with Section 40 of the Act. It would appear from the observations on page number so and so of the sixth edition of Frames on Statutes of Statute Law that there are three kinds of laying: laying without further procedure, laying subject to negative resolution, laying subject to affirmative resolution. The laying referred to in subsection 3 of section 40 is of second category because the above subsection contemplates that a rule would have effect unless modified or annulled by the House of Parliament. The act of the central government in laying the rules before each House of Parliament would not, however, prevent the courts from scrutinizing the validity of the rules and holding them to be ultra vires if on such scrutiny the rules are found to be beyond the rule-making power of the central government. Similar views, my lordships, are taken on the next judgment. This is a constitution bench judgment.
Which one?
Next one, page 30, Kerala State Electricity Board. In this case, an order was issued. There was Essential Commodity Act, and an order was issued under that declaring electricity as an essential commodity, and that was challenged.
Just wait. Then?
Yes, it starts from 10. Relevant part is at page 29, para 25.
Yes.
The question still remains whether when a declaration is made under section 2A of the Act declaring an article as an essential article or an order is made under section 3, such a declaration or order becomes part of the Act. In England, even where an statute declares that subsidiary legislation shall have effect as if enacted in the Act, it does not preclude the court from calling in question the subsidiary legislation where it is inconsistent with the provisions of the Act. But it would appear that where the statute provides for the laying of the rules before Parliament and the Parliament could have annulled them, such a provision would make the subordinate legislation beyond challenge. In India, many statutes both of Parliament and of state legislature provide for subordinate legislation made under the provisions of those statutes to be placed on the table of either the Parliament or the state legislature and to be subject to such modification, amendment or annulment as the case may be, as may be made by the Parliament or the state legislature. Even so, we do not think that where an executive authority is given power to frame subordinate legislation within stated limits, rules made by such authority, if outside the scope of the rule-making power, should be deemed to be valid merely because such rules have been placed before the legislature and are subject to such modification, amendment, or annulment as the case may be, as the legislature may think fit. The process of such amendment, modification, or annulment is not the same as the process of legislation, and in particular, it lacks the assent either of the president or the governor of the state, as the case may be. We are therefore of opinion that the correct view is that notwithstanding the subordinate legislation being laid on the table of the House of Parliament or the state legislature and being subject to such modification, annulment, or amendment as the case may be, the subordinate legislation cannot be said to be valid unless it is within the scope of the rule-making power provided in the statute.
Mr. Counsel, just 1 minute.
Yes.
In this, in the case which you have referred to,
My lordship.
Whether the authority had the power to make the rules? No.
Yes.
No.
So in this judgment, my lordship, so there was an Essential Commodity Act and a power was given to the government to notify the products whether they qualify as an essential or not. Under those powers, they notified electricity as an essential commodity. That was challenged before the court. And one of the grounds raised was that since this notification or this order has been placed before the parliament, so they have
No,
confirmed.
that is another thing that I'm not. But here, the order, the judgment refers to some rule
Yes,
being made.
yes. So that is again in delegated legislation. In exercise of that power is the first paragraph.
understood. No,
Yes.
no. You see, if a person, just for example, you have the
Yes.
CGST Act.
Yes,
The CGST Act also empowers the central government to make rules.
yes, yes,
Now, the state government makes the rules for the central government
yes, my lordship.
and lays it before the parliament,
Yes,
and the parliament sleeps over it.
yes,
Then obviously it can
Hmm.
be.
yes,
It will nullify it because it cannot be done by the state government on for the CGST Act.
correct.
Now,
Correct.
we are not concerned with that.
Yes.
My specific question is
Yes,
that taking into account the Mohit Minerals judgment,
yes,
wherein it says that the provision of the recommendation made by the GST
yes,
is recommendatory or persuasive only for
Yes.
persuasive value
yes, yes,
and not binding, then in that regard, when they sought for a recommendation in the 49th meeting asking that we want it for till the March 2024 and August 2024, which was rejected, and made it only to the tune of December 2023.
yes,
Whether that notification, whether that thereupon it is passed by the central government by issuance of the notification number 56,
yes, my lordship.
which thereupon was laid under 166. And the parliament did not do anything.
Yes,
The power to make the notification is there.
yes,
The only thing is without the recommendation.
yes,
Now, without the recommendation or rejection of the recommendation and laying it before the parliament, which the parliament did not do anything, can be said to be of equal balance with what has been decided in both these cases?
So, my lordship, there is one point. As far as the Mohit Minerals is concerned, the Honorable Supreme Court has said the recommendations are not binding, but in the very same judgment, they have also clarified that the Act itself has specified the provisions where such recommendation would be mandatory. So, like if the GST Council can give 10 number of recommendation, even if the Act doesn't want them to give, then it is not binding on the center. But if the Act itself provides that it has to be on the basis of recommendation of GST Council, then it is mandatory. And I show the relevant paragraph. I put that in my compilation.
You're referring to para 66?
In my lordship, just page 67 of my compilation, para 58.
Page?
Page 67,
Yes.
para 58, last line. Interpretation of recommendation vis-a-vis the provisions of IGST Act and CGST Act. The contention of the union that the recommendations of the GST Council are binding, since Parliament and the state legislatures have agreed to align themselves with the recommendation, as is evident from the provisions of the IGST Act and CGST Act. This is important, my lordship. Certain provisions of the IGST Act, CGST Act, and SGST Act expressly provide that the rule-making power delegated to the government shall be exercised on the recommendation of the GST Council. So certain they have dealt with it. Then they have quoted the example. This is not relevant. Then para 59. The provisions of
Then read the same thing only.
yes.
For
For-
instance,
for
Section
instance,
5 of
yeah.
the GST Act
Yes,
provides that the taxable event, taxable rate, and taxable values shall be notified by the government on a recommendation of the council.
yes,
Similarly, the power of the central government to exempt or
Yes.
service or both for the so and so on the recommendation of the GST Council under 6.
yes,
Section 22 provides the government may exercise its rulemaking on the recommendation of it. The
Yes.
CGST also provides for CGS similar provisions in section 9, 11, and 164.
Yes, my lordship.
Provisions of AIA which provides the union is to act on the recommendation must be interpreted with reference to the purpose of the enactment, and which is to create a union. Was introduced since different states could earlier provide different tax slabs and different exemptions. The recommendation of the AIA are made binding on the government when it exercises its power to notify secondary legislation to give effect to the uniform taxation system. Now, this is the line.
Yes.
This creates all the confusion.
Yes. The council under article, my lord, that time?
The council under article
Yes.
has wide discretionary recommended on matters relating to GST when it has the power to make recommendation on subject matters that fall outside the purview of the rule-making power under the so and so. Only because a few of the recommendations of the GST are binding. Now that is
Correct.
why this is very relevant.
Yes,
This
my
way,
lord.
some are binding, which the Supreme
Yes.
Court also acknowledges.
Yes.
Now,
Yes.
a positive act to do a certain thing, just
Correct.
for example, what would be the taxation rate
Yes.
or which will be the taxable event,
Correct.
this would be binding
Yes. So even
under
that is
the
what.
provisions of the CGST Act, and it cannot be argued that all GST recommendations are binding. As a matter of first principle, the provision of the Constitution, which is the ground norm of the year, cannot be interpreted based on the provisions of the primary. It is only the provisions of that. Now tell me, what was the case in Mohit Minerals?
Mohit Minerals was regarding ocean freight, my lordship. So, like if I am an importer in India and I'm placing a order out to a company outside India for import of a consignment, and it's on that FOB or CIF basis. So the foreign supplier engages a shipper outside India. The shipper is outside India, the supplier is outside India, and the importer in India. My cost includes the insurance and the freight part also. I have paid a lump sum money to the foreign supplier. The Indian government tried to create a deeming fiction that in this case the the freight services is provided by a separate shipping company, and under reverse charge mechanism they by deeming fiction they wanted that Indian importer to pay tax on that service. So they created a deeming fiction for that, and that they done by way of a notification, and it is in this
But the
context
notification with the recommendation of the GST.
with the recommendation of the GST Council.
And then says that it is binding because it has been done by the GST.
Correct. That is what. So the argument of the revenue, but there were two arguments. My lordship, they said that once the GST Council has given a recommendation, that is a legislation in itself. The Parliament need not pass any act. That was one of the stands taken by the union. And the second, they said that the recommendation is binding in nature. In that context, they said that even though if there is a recommendation by GST Council, there has to be a formal law that has to be formulated by the Parliament.
Yes, then read.
Which paragraph, my lord?
62.
62 is with respect to that ocean freight. A statutory interpretation will determine whether the IGST Act confirms the power on the central government in consultation with the GST Council to designate imports as a supply of services under Section 5(3) of the IGST Act, and whether the import can be considered as the recipient of such supply liable to pay tax on a reverse charge basis. Further, it will determine if the central government, in consultation with the GST Council, has the power to designate the importer as a recipient of a service under Section 5(4) of the IGST Act when goods are imported on a CIF basis. The critical fact in this case is that the service of shipping in these CIF contract is availed by the non-taxable exporter who engages and pays a foreign shipping line of their choice without the involvement of the importer. In contrast, in FOB contracts, the Indian importer pays for the services of shipping and directly deals with the shipping line. The respondents herein are importers of non-coking coal on a CIF basis.
But the section 5 says, subject to the provisions of Section, there shall be levied a tax called the integrated tax on all interstate supplies of goods or both except in the supply of alcohol. So, what does 2 say? Now here,
My lordship.
type 3 of the IGST Act, if you
Yes.
see, that the government may, on the recommendation of the council,
Correct.
by notification specify categories of supply of goods or services or both, the tax on which shall be paid on reverse charges, basis by recipient of such goods or services or both, and all the provisions of this act shall apply to such recipient and he is liable. Then number 4, the government may, on recommendation by the notification here.
Yes.
So are you saying that these notifications the government cannot issue without the recommendations?
So, my lordship, what was this section 4 says? The service recipient. So, as far as that shipping services are concerned, I have placed order onto a foreign supplier and he has engaged a shipping company. So, shipping company has provided service to a foreign supplier and not to me. By way of a deeming fiction, they said that you are the service recipient. And it is in that context the Supreme Court said
No,
that
I
the-
understand, Mr. Jain, I understand on that aspect. There's no
Yes,
quarrel
yes.
with that.
Yes.
Are you saying that though it has been held to be persuasive and all in Mohit Minerals and all, but for issuance of a notification, even under 53, 54 and 55,
Yes.
the recommendation of the council is necessary?
Yes. Yes. Absolutely necessary.
Then why did the court hold it that it is only persuasive?
No, it is not in this context because in the section, that is what I was saying, subsection 4 says only with respect to service recipient. It doesn't empower GST council to notify a person as a service recipient when he is not. So section 4 says that you can tax a person under reverse charge mechanism if he is the service receiver. It doesn't empower GST council to give a recommendation to nominate a person as a service receiver, which the GST council did. And then it is in that context says that just because GST council has given a recommendation, that doesn't empower the government to formulate a notification. It is in this context they held.
Then why did the Supreme Court rely on 246A?
So 246 is the charging section. So that is there we said that if it was the case that the recommendation from GST council has transformed into a law, it's a mandatory recommendation, then the necessary provision should have been made under 246A itself, whereas the GST council is under 279. So that it is in this context they refer to 246A. That if it was binding, then there are provisions should have been made under 246A itself.
Or earlier, which was there, 279B, which was modified.
Yes. So GST council is under 275B.
So you mean to say that if it is something positive to be done,
Yes.
without a recommendation of the GST council, you cannot.
So if the section provides that it has to be on the basis of recommendation, then you cannot.
And
So yes.
if it is done also, means then, and if it is not recommended, you cannot.
Yes. Yes.
And if it's a recommendation refused, then can you?
So that is what my lordship 168 says, that may on the recommendation of the GST council. So now the government has the power. So if they have to do something under 168A,
So the
it has to
power
be,
still remains with the government.
yes, says. So
The issuance of notification is with the
Yes.
government.
yes,
Everything is with the government. Now,
Yes.
under such circumstances, if a recommendation is refused,
yes,
then
they
what
can
happens?
do. They can do. While that is practically is not happening, but that is very much possible, my lordship, because it uses the word
But
may.
can't we take it here?
Yes.
The recommendation was refused beyond August 2023.
Yes. That
Beyond
is what
December 2023.
correct. So
And if
for
the
the
recommendation is refused,
yes,
they have taken the stand.
Hmm.
And we have sought for a recommendation, and the recommendation was refused beyond this. It's a different thing. Somebody
Yes.
has filed an affidavit out here, it's a different thing.
correct.
GST can file any affidavit they feel like,
Yes.
some officer. But the question arises that if a recommendation is refused, can they still act under 168A?
No. First and foremost, my lordship, there is nothing to show that even they have sought even a recommendation, because after the 49th meeting, in the 50th, 51, 52nd, there is yeah,
No, Mr. Jain.
yes,
A sought for till March 2024
yes,
and August
yes,
2024.
yes, that time they
This
sought.
was refused and said there's nothing doing. People will be harmed and all. So we only give you till December, and
Yes,
accordingly they have come up. Isn't
correct,
maybe another submission that
correct,
on the basis of that they had come up only up till August, December 2023. They came
yes,
up.
yes,
And as such have
yes,
duly accepted the 49th,
yes,
and there has to be a fresh recommendation
yes,
or refusal.
yes,
Another line of submission.
yes, yes,
But
my
if
lordship.
there is a refusal also,
Hmm.
the power still remains under 168A.
So, but this power can be exercised only on the recommendation. So, if there's a positive recommendation, then only it can be done.
So
And that is
therefore
what
I'm
the Supreme,
saying,
yes,
what is the meaning of the last paragraph, last portion of paragraph 59?
yes,
Because there it says that the power is there under 246A.
correct. Huh. So then, my lordship, they should amend the act and they should recommend the word that on the recommendation they should remove, because that is what the Honorable Supreme Court said.
No, the Union of India always thought the recommendation was binding.
But this
It's a different thing. It's an interpretation being given by the Supreme Court. The recommendation is only persuasive.
No, my lordship, but Supreme Court has said that where the section itself provides, then there is a binding. Because 58 per second line, my lords can have page 68 second line. It says certain provisions of the IGST Act, CGST Act, SGST Act expressively provide that the rule making power delegated to the government shall be exercised on the recommendation of the GST Council. So if the provision says it can be exercised only with the recommendation, then
Mainly
it is
because a few of the recommendations of the year are binding on the government under the
Yes.
provisions of the year. It cannot be argued that all the GST recommendations are binding.
Yes, madam.
As a matter of first principle, the provisions of, now this is the problematic area. As a matter of first principle, the provisions of the Constitution, which is the ground norm of the Constitution, cannot be interpreted based on a provision of a primary legislation. It is
Correct.
only the provision of a primary legislation that can be interpreted with reference to the Constitution.
Yes.
The legislature amends the Constitution by exercising its constituent power and legislates by exercising its here. The constituent power of the legislature is of higher constitutional order as so and so. Even if a parliament that has enacted the law making recommendation of the GST Council binding on the central government for the purpose of, now this line, notifying secondary legislation, it would not mean that all the recommendation of the council made by virtue of its powers under Article 279 have a binding force on the legislature.
Yes, so exactly.
That's
This
a
is what.
problem. Now, these are secondary legislations.
So that is what exactly, my lordship, this what says that if the act provides, then it has to be made on the recommendation of council. So the GST council can give 10 recommendations, 5 provided under the act, 5 not provided under the act. Because ultimately there has to be consensus, so everything happens on the basis of recommendation. So like 168A, it is act specifically provides that it has to be on the basis of recommendation of council. Assuming there is another section where nothing is to be done on the basis of recommendation, this word is not there. Assuming the GST councils gave a recommendation even in respect of that section also, then it is for the parliament whether to accept or not to accept. But as far as 168A is concerned, if they want to do anything, it has to be done only on the basis of recommendation of council. And that is what Supreme Court says, that merely because on certain sections it is binding, that does not mean that for all the sections it is binding. So where it is binding, then it has to be basis of recommendation.
But the last portion of the line of that paragraph makes it. Even
Yes.
if the parliament has enacted laws making recommendation of the GST council binding, now this
Correct.
is binding,
Yes.
on the central government for the purpose of notifying secondary legislations, which will be in day,
Correct.
it would not mean that all the recommendation of the council made by virtue of the powers under Article 279 have a binding force on the legislature. Now, the exercise of the power by the GST flows from 279A.
Yes, my lordship.
And if you see the previous segments of this judgment itself,
Correct.
kindly come to paragraph 52. This is a very
Yes.
important paragraph on what
Yes.
type of recommendations.
Yes. So this is the
Now,
constitution.
number 3, kindly
Yes.
come to category 3.
Yes.
Recommendation with accountability.
Yes. Article. May I read, Manoj?
Yes, sir.
Articles 243I, 243Y, 280, 81, 338, 338B, and 340. Articles 243I and 243Y stipulate that the Finance Commission shall make recommendations to the governor on apportionment of taxes to the panchayats and municipalities. Article 280 states that it shall be the duty of the Commission to make recommendations to the President on the principles governing distribution of taxes between the Union and the states. Article 281 fosters accountability by providing that every recommendation made by the Finance Commission shall be laid before the House together with an explanatory memorandum on the action taken on such recommendations. Article 338(5)(e) states that the National Commission for Scheduled Castes shall present a report to the President annually listing the measures that should be taken to enhance the protection and development of the scheduled caste. Article 338(6) states that the President shall cause the report to be laid before the Parliament along with the memorandum explaining the action taken on the recommendations or the reason for non-acceptance, if any. Article 338A is a similar provision on the recommendatory nature of National Commission for Scheduled Tribes. The President has the power to appoint a commission to investigate the condition of backward classes. The commission is required to investigate the matter referred to them and present a report along with the recommendation to the President, which shall be laid before the Parliament along with an explanation memorandum.
53, a survey of above provisions indicate that the nature and meaning of the term recommendation differs contextually. All the provisions qualify the nature of the recommendation. For first instance, in category 1, the recommendation of the President is for the initiation of a discussion.
Yes.
In category 2, a decision on the recommendation is arrived at upon consultation. Category 3, the decision-making authority has to submit an explanatory note on the basis of so and so. Category 4, the recommendations are not qualified. Article 263 only states that the interstates have a duty to recommend. There is no further explanation of whether the recommendation ought to be mandatorily accepted or deliberated upon. In category 5, the recommendation of the are expressly stated to be binding on the decision-making authority.
Yes.
Read category 5 again, then.
Recommendations which are obligatory in nature. Article 270, 275, 344, 349, and 371A. Article 344 establishes the Commission and Committee of Parliament on Official Languages. Article 344(2) states that it shall be the duty of the Commission to make recommendations to the President on the usage of official languages. Clause 3 states that recommendations shall be made having due regard to the industrial, cultural, and scientific advancement of India and the claim of non-Hindi speaking persons. Article 344(4) constitutes a committee of the members of the Lok Sabha and Rajya Sabha. The committee will have to examine the recommendation of the Commission and report its opinion to the President. The President shall, considering the report, shall issue directions in accordance with the whole or part of the report. Article 349 deals with the special procedure for enactment of law relating to language in the first 15 years from the commencement of the Constitution. Article 270 and 275 stipulates that the percentage of tax apportionment and fixation of the grants for the states from the Consolidated Fund of India shall be ordered by the President on the recommendation of the Finance Commission. So it is in the context, my lordship, when the Act, the Constitution itself provides the cases where the recommendation will be binding. As far as 279 is concerned, the Supreme Court said that it is not binding on the Parliament. However, if it is provided in the Act itself, then it becomes binding.
Finally, come to 56. If the GST Council were intended,
Yes, whose recommendations transform into legislation without any intervening act, there would have been an express provision in Article 246A. Article 279A does not mandate tabling the recommendations in the legislature like the provisions in Category 3, where the recommendations have to be mandatorily tabled in the legislature coming with an explanatory note. Only the secondary legislation which is framed based on the recommendation of the Council under the provisions of the CGST Act under Section so and so is mandated to be tabled before the House of Parliament. The use of the phrase recommendations to the Union or states indicate that the GST Council is a recommendatory body aiding the government in enacting legislation or GST.
this What do you say on this, Pat?
So that is what my lordships, if the GST council is a recommendatory body, that we are also not running away from this fact. However, the Supreme Court clarified that my lordship why it is relevant, because assuming in the instant case, if union extends the date, suppose 31st December, and a state does not extend the date, now what will happen in such a scenario? Or if there
Huh?
is a but
What did you say?
if the under the CGST Act, the center government extends the time limit for passing the order till 31st December. However, the state of Assam does not issue a notification for extending the time limit. Then what will happen? So it is
No,
to
no,
bring,
in this case,
yes,
if you see the UP case,
yes,
the Allahabad High Court judgment, they have, in that case, it has already been extended by the UP government till 2024. And there is a recommendation by the GST. See, the difference which Mr. Kyle on the last occasion produced out, in the case of both the Kerala and Allahabad, both are cases where recommendations are there from the GST, unlike in the instant case.
Hmm.
So therefore, the Kerala and the Allahabad, both judgment can't be applied here.
yes,
So
yes,
that is not the point here, because
yes,
in those cases there is there, and the question out there is primarily on the question of whether it would constitute the force majeure,
yes, yes,
which is a secondary question, which
yes,
another aspect which we looked into.
yes.
But otherwise, don't you think that this recommendation which is there, yes, madam, what do you have to say?
Lordship,
I'll hear you, Mr. Jain. Yes.
Yes. Oh, no.
like to just brief the entire case, Lordship. Lordship, may kindly that what exactly was the time limit for Lordship completion of assessment under
I know that.
Lordship?
I'm not on that. My question is it's a pure question of law. It is a case where whether without a recommendation or a recommendation being rejected, the 49th meeting, then also going ahead with a notification under 168A, can it be done?
First, Lordship, section 168A. Lordship, during the year 2017, 18, 18, 19, 19, 20. Lordship, 168A was not in the statute book. It was inserted later on after coming into effect of COVID. Because of giving, that something has to be done so far as COVID is concerned, some relaxation has to be given. Otherwise, there was no power even to the legislature, given to the legislature under the Parent Act to extend the time limits of passing the order of assessment. It was only because the Relaxation Act was passed. That is why in the Relaxation Act, under clause 7, this 168A was inserted. So this 168A, Lordship, which was inserted under the Lordship GST Act, only gave them the power. So the power has to be seen according to section 168A. It cannot go beyond that. And 168A has very clearly laid down that if you want to extend a time limit, that 3 years which I have provided to you, that you can extend only. The government may after the may there is a comma, Lordship, that has to be read because it's a taxing statute. It has to be read very strictly. Even a comma has to be given a meaning. Lordship, it is written the government may. It is right that not in every case they have to extend the thing. It means that on the
No, it
recommendation
may
of the
be a
council, it's
taxing
important.
statute. No, madam. Taxing statute has to be construed strictly insofar as the imposition of the tax is concerned. But as regards a procedural provision or how it is to be there, I don't think that the strict interpretation would be there. It would amount to a purposive interpretation.
If Lordship, this GST Act wanted the Parliament to do whatever they want to do, whenever they want to extend the dates, if the Parliament wanted to do, they should have enacted 168A, the Parent Act. They have enacted 168A only conditionally, only for certain giving certain conditions.
Because at that point of time, COVID was not there.
Yes, Lordship, the COVID was not
They
there.
never thought that
70
something like
will
which
come up.
will happen out here.
Lordship, even we did not think that 70, when we were doing Lordship, all these cases are relating to 1819, 1920. Because 5623 covers only 1819, 1920. Not
Yes, what
17,
is
18.
your case?
But my 1819. My case.
No, I understood. Why 73-9 order has been passed in your case?
Lordship, because 17 and 9 because of the extension under section 56, 20, 23.
Why? There's a reason 73-9 order is passed. Why?
Because of 16.4, I have filed.
16.4, you can go there. You can very well get it up till 2021. Why are you there?
No, Lordship, now.
You only have to withdraw the writ petition. That is it.
No, Lordship, it cannot be withdrawn. It has to be, an order has to be passed by this, because what they have done, Lordship, even though GST Council in the 53rd meeting has passed a finance bill, but it is not automatic, Lordship. It has to be implemented. Even today, Lordship, even after the bill has been passed, some of the orders the officers are passing, they said that you can go to the court and get it set aside. But till now, it is not an act. Unless
one?
until it becomes this, Lordship, the GST Council meeting, the bill which has been passed, finance bill, in the proposal, Lordship, it is just a bill. It has not yet become an act. It requires another 3 to 4 weeks to become an act. When the Lordship, the proposal was given in the 53rd GST Council meeting, then also they were passing orders.
Again, GST Council meeting has no relevance out there. It's recommendatory. It cannot do anything that you do this, you do that, and all these things. Because if you see, the 279A, it also says the GST, apart from the GST Act, can also make recommendation in any other matter touching on the GST Act. So under such circumstances, the GST Council may make other recommendations also.
GST
Now
Council
the question which needs to be decided is as to whether the Supreme Court's observations to the effect as saying as to be binding in some and otherwise not is only limited to those which come under 279(4)(h). Any other matters is not binding, or others will be binding.
Lordship, if it is, Lordship, as my learned friend had said, that if it is provided under the specific section, then it is binding. If the section does not provide, and recommendation of council, Lordship, it is only taken as an analogy. It is not binding. The legislation may adopt it, not adopt it. But if it is given directly in the section, then Lordship, the legislature is also bound by it. They have to take the recommendation of the council. If the recommendation is not there, end of the matter.
Okay, let me come back. I have a full bench. It will take 10 minutes and I'll be back.
Obvious.
I was going through Mohit Middle. The Mohit Miller's Lordship, the last but no, 2-3 paragraphs which is there. It says, Lordship, I'll read only. Government, while exercising its rule-making power, that's government, under the provisions of CGST Act and IGST Act, is bound by the recommendations of GST Council. Anyway, they are bound. But, however, that does not mean that all the recommendation of GST Council made by virtue of power under Article 294-79A4 are binding on the legislature power to enact primary legislations. Lordship, this is this we cannot controvert, that all the GST Council, whatever they are recommending, they are not binding on the legislature.
Constitution condition.
They are not binding on the legislature. But Lordship, this Lordship, the 168A, the Lordship, the provision which has been enacted after Lordship taking the assent of a President of India. This is binding on CBIC, Lordship. CBIC. The CBIC has issued this notification, Lordship. 56/2023 has been issued by CBIC, Central Board of Indirect Taxes and Customs.
Not by the government?
23 by CBIC. Kindly see page 2 of my compilation. I have given the 56/2023 is by CBIC. It is binding on CBIC, Lordship. And specifically, once it has rejected it, once the Lordship, Lordship, it was law committee has recommended how it till August.
Now, kindly come to the Constitution,
Yes, Your Lordship.
Article 279A(4).
The Goods and Service Tax Council shall make recommendations to the Union and States on number A, Lordship. There are, Lordship, till H.
So A, B, C, E. These are comes within the ambit of this section 5, 6, 7 and all these things.
Yes, Your Lordship.
But-
Yeah,
But the recommendation which is being made under 168A,
yes, Your
would it come within the powers under A to G,
I think so. It will come under
H?
any other matter because when this Lordship provision was enacted, 168A was not in picture. Nobody comprehended that 168A will come anytime in future.
Now, if it is done under H and the statute provides that there is a recommendation to be made, and the recommendation is declined,
Right. That is the,
then what happens?
then Parliament Lordship still has the power. But
No.
yes,
The government would have the power.
government will have the power if the recommendation is not made. But if it has been rejected,
It is, that is what,
then it will not.
no, why not? Because it is not binding.
So far as 168 Lordship, those so far as those act is concerned, in which the act specifically provides that there has to be a recommendation of council. If it is rejected by the council, then Lordship,
No,
if
understood,
it is
but
not,
how do you take care of the situation where the Supreme Court categorically observes out here in paragraph number 56, I suppose, 59, 56. If the GST were intended to be a constitutional body whose recommendation transform into legislation without the intervening act, they would have there would have been an express provision in Article 246A and Article 279 does not mandate tabling the recommendation in the legislature like the provision in category 3 where the recommendation have to be mandatorily tabled to the legislature along with the express. Only the secondary legislation which is framed based on the recommendation of the council under the provisions of the so and so is mandated to be tabled before the House of the Parliament. The use of the phrase recommendation to the Union or the states indicates that the GST Council is recommendatory body aiding the government in enacting the legislation on the GST. So under such circumstances, if a recommendation is rejected, which happened out here by the 49th GST Council, then would it come within the ambit of can you say that 168A, the recommendation was not made, or whether the recommendation at all is required? Understood. If it was a case coming under 279A to G is another aspect of the matter. We are coming under in 279 4H. Then 4H, what will happen? Yes, Mr. Kyle, it's very difficult to find you. Yes, tell me. You have filed an affidavit supporting the case of the petitioners. Yes. Paragraph 3.10.
Paragraph 3.10.
3.10. You say that we have not taken the recommendation. But we are going to get it ratified. You can't ratify it. How can you get it ratified? The last portion of it. Where is that affidavit? I don't have a copy. Somebody gave me a copy of the affidavit. Yes, yes, got it. Yes. 3.10. 3.8. Kindly come to page 7 of that affidavit. 6. The time limit for issuance of a demand notice under Section 73 of the Act for the financial year 2018-19 was going to expire on 31/12/2023. As per the present timelines, and since no GST or meeting of the GST Council was scheduled to be held during that period, owing to the urgency of the issue, the matter was deliberated by the GST Implementation Committee and agenda was approved on 26/12/2013, and accordingly notification so-and-so was issued after following due. The same will be placed before the GST Council for ratification in its next meeting. Meaning thereby there is no recommendation. Meaning thereby you accept that the earlier recommendation was only till 31/12/2023. Meaning thereby that you require a recommendation. Meaning thereby that without a recommendation you could not have issued. That is why I said you filed an affidavit supporting the case. What do you have to say? Isn't it a constitutional provision read with the statutory provision? Why such a careless attempt on your part to file an affidavit in this manner? The 49th meeting categorically shows that there was a request to do it to the to the period of March 2024 and another to August 2024, which was specifically rejected, holding it to be only up till 31/12/2023.
Opinion recommend. Copy to will also last topic.
Yes, kindly come to here in this thing only. Kindly come to page 4.1. The issue was deliberated by the law committee in its meeting held on so-and-so. The law committee took a view that it is not desirable to extend the timelines in such a manner so that it may lead to bunching of last date of issuance of SCN order under 73 and 74 for a number of financial years. Accordingly, LC did not agree with the proposal to extend the time limit under section so-and-so to the timelines under section 74 for a financial year. Further, LC did not agree with the proposal to extend the timelines from so-and-so, so-and-so. However, LC felt that considerable delay in scrutiny audit so-and-so due to restrictions and difficulties faced by COVID, they may be needed to provide some additional time under section 73 and financial year in such a case so that there is no bunching of so-and-so. LC accordingly recommended that the time limit under 73 for so-and-so may be extended till so-and-so, so-and-so, and year to Iman. A draft notification of the year as per the recommendation of the year is placed as annexure A. So this is up till then. Minutes books, kindly see what has happened here. Here, kindly see here. Kindly come to page 5, 5.7.1. The secretary stated that the law committee has recommended the extension of the time limit for issuance of SN. However, the time limit for issuance of notices and passing of these fines have already been extended considerably due to extension of time due to filing of for so and so. Further, FY so and so, the date of passing of the order has been extended till September 2023. It has been proposed to extend it further from September to December. He mentioned that while the request of some of the tax administrators was to extend the time limit for a longer period, however, keeping the taxpayers' interest in view, the law committee has recommended an extension of only 3 months for these financial years. Since all the states have agreed, the said time limit could be extended. Honorable member for so and so stated that while this proposal could have been considered, however, it should not be decided that such extension in year for the fire is for the last time. The council, with the recommendation of the so and so made in Iman along with the proposed so and so. So accordingly, it was extended. It has accepted this till 30th of year. We are concerned with which financial year?
There are different
Different cases, different year.
1920 is till 31st of
30th of June 2024. 30th of June 2020. 1920. Lordship may kindly see my compilation, page 48. I have given that
1920 last date is till 31st of August, my lordships,
of
of 2024. As far as
I
1920 is concerned, for passing the orders, for majority of the cases we are concerned here is pertaining to 1819, for which the last date was 30th April.
1st March is recommended, Lordship.
the 31st of March 2024.
Yes, 31st. Initially it was 31st March and then it was extended till 30th April. Second extension. So we are challenging the second extension.
But in this 49th meeting, they have
Notifications. Timing takes my paper book, Lordship, very clear, because I have given the whole bunch of the 49th meeting. Lordship may kindly see page 48.
page
48. But Lordship, this is what is in the Lordship. The proposal. This is the Lordship final thing which comes out.
LC recommended, proposal recommended that the time limit for the so and so may be extended below to so and so. For 2017 in Iman, so and so may be extended from September to 31st December. This is for 1718.
Yes.
And for FY 1819 from December 2023 to 31st March 2024. And for FY 2019 and 20 from March 2024 to 30th of June 2024.
This is recommendation of GST Council. And accordingly, Lordship, they have issued this notification. This is at page 1.
Page,
Notification has been issued, page 1 by CBIC.
page 1.
9 of 2023. Has been issued.
Okay, then
Lordship, that again, page number 2 is 56/2023, which is the subject matter, Lordship. That was within the time which was recommended by the council.
so 1718 is not the issue.
Not the issue, cannot be, Lordship, because it is the
So
issue.
there was no extension by this 56 also.
No, by, not by 56 also.
So anybody has a case of 1718,
Any cases are there.
Yes.
Huh?
Any cases are there of 17.
but there is no extension
Bunch of
even by 56.
56, lordship,
My lordship, in those cases, it has been challenged on the ground of force majeure, not on the ground of recommendation.
is force measure only. Force measure.
Where?
Yes,
Those 1718.
they challenge the virus of the force measure that the department is no ground to.
So it is on a different point. But in respect to 1819 and 1920, it is 30th of April 2024, which was 31st of March 2024. And this is for, this period is extended for passing an order under 79(3), 73(9). Extend the time limit specified under subsection 10 of section ER for issuance of the order under subsection ER for recovery of tax. So all orders for 1920, 1819 has to be passed by 31st of March 2024. And for financial year 1920 till 30th of June 2024. Isn't it? Now, in all these cases, in Mr. Jain, your case is
In my
falling
case is
under
1819.
1819.
Yes. And all the orders have been passed after 31st March. So by virtue of the second extension.
Order passed on 11/1/2024.
No, my lordship.
Is annexure K, page 49.
Annexure K is not my file.
Item
15, 16, 17, I think. Thanks, item.
Page 49.
Which
Annexure
petition number?
K
Because
in
and by
WBC number 3585.
that is not my matter, my lordship.
Huh?
That is not my matter. Mine is 3661, 664.
Walkie-talkie print and media services is whose? So here the order has been passed within the time. 26th April. Or notice was issued there. So this period is over. Okay. And your matters, this is this case, no?
It is item number 15, 16, and 17.
Yes, mine are 15, 16, 17.
Hmm?
15, 16, 17.
Mr. Mishra, your cases are 3585 and 3607. 3607 is for show cause notice on 31 year for financial year 1819. 1819 can be given up till Iman, and the order was passed on page. Order was passed on 23/4/2024. Okay. Okay. Chalo. And this is 3607, 3585, and 3610 is whose? Where? No, this is a case of 1718. Huh?
18, 19 looks.
1819. And here the order was passed when? 16/4/2024. And this was not extended by the earlier 31st of March 2023. Okay, yeah.
It's for consideration of lot. See.
And Mizo
That is my
Publication Private Limited.
that is my matter, my lordship. The order
Yeah.
is passed on 30th of April.
Huh?
30th of
This is
April,
which year?
1819.
1819.
Yes. Annexure 7.
And this Arunachal what?
This
Sports and
is
Events Private Limited.
this is passed on 29th of April.
This is for 1819.
1819. All are for 1819.
Your all are for 1819.
Yes, my lordship.
And madam, your
is also 1819.
1819.
Your lordship.
So now, no case of 1718 or 1920. You don't have any case of 1718 or 1920, Mr. Jain?
No.
You also don't have.
I have Lordship. Tomorrow it is
No, that is a different thing, but not here.
24/4/2024.
So you have challenged on two grounds. First is the ground of no recommendation, and the second, there was no force measure.
Because if force measure was there, the recommendation of GST company is rejected. It shows that now there is no more any force measure is there. COVID is already expired. So again, if you are asking for an extension, if you are given an extension second time, how many times the COVID was there? The COVID must have existed only for once. It cannot keep on going. Like again, you want extension. That is why you are taking extension. It is not because of COVID that you are taking extension. Lordship,
So your case is that earlier you sought for an extension.
for COVID.
Now you are not in a position to do it, which should not come within the ambit of force measure. That's your submission, isn't it, Mr. Jain?
Yes, my lordships.
If, furthermore, the present proposed amendment, it is taken away all the notification and they have recommended. Lordship, section 16.4 new section has been proposed to be amended. It is, I'm reading slowly, on last occasion Lordship, recommendation was given to your Lordship. The proposed Finance Act.
You are saying what?
So I'm saying that new section has been proposed to be added in section 16 of the GST Act. This reads as follows. Notwithstanding anything contained in subsection 4 in respect of an invoice or debit note for supply of goods or service or both pertaining to the financial year 1718, 1819, 1920, 20 and 21 till 21. The registered person shall be entitled to take input tax credit in any return under section 39 which files up to 30th day of November 2021.
Then?
So Lordship, all the cases become in process by this.
No, my lordship. My case.
Mr. Jain.
Oh,
I may be
Obla.
wrong. I am
Okay.
entitled to submit with your Lordship. So my submission, Lordship.
No,
is,
Mr. Kyle, kindly see. His cases are, some cases are, he did not file any return.
If return is not filed, then they are not entitled.
Huh?
If they have not filed return, then they are not entitled to any benefit under the new provision of that.
No, therefore, if he has not filed any return, can you take action in respect to that financial year?
Here, Lordship, time limit was there. It is 664 and different high courts upheld the provision of the law, Act Lordship. Then this extension was granted in by the GST, whether it recommendation or not, that is for consideration. And time limit was extended. And in 53, because there was a lots of cases were filed in different high courts, then the government think it fit.
But there were recommendations.
No,
The
no,
cases which were pending before the Kerala judgment
yes,
was a case of recommendation.
yes, Lordship.
The Allahabad judgment is also a case of recommendation.
Yes, there may be some difference also, but
That is the main difference.
but Lordship, now all these things have been done away by
Eh?
this proposed amendment. But this proposed amendment, all the person who have filed their return up to 21 for the financial year.
No, that is only for 16.5 is only for the filing of the return up till 2021.
21. Those
He has not filed a return only.
no, probably everyone has filed return.
Huh? He has not filed the annual returns. What?
They have taken ITC lots. Limited return has been filed. Now department is issued notice to recover the amount because they were filed. They have taken the ITC beyond time. That is the reason, Lordship. Lordship, please to speak. This is the notice says. Lordship. Everybody has filed return, and Lordship now it has been extended till November 2021. Yes, discussion is going on in Parliament. There is no question of result from the stand taken by the state government, central government. Today or day after, within a week or 2 weeks, the act will come into force. All the petition will get benefit.
You guarantee?
Yes, Lordship.
Given undertaking, everybody, all petitioners will be
Yes,
getting
yes,
benefit
yes.
under the finance bill.
Yes, Lordship.
File an affidavit.
My lordship,
Yes, Lordship.
Let
but
him give me a, let him file.
If.
Or you file an affidavit that all the petitioners out here would be getting, because his case is under section 16(2)(b), wherein there is no benefit being given to him in view of his, the person from whom he has purchased have not paid
That
the
is-
tax.
That is a.
How do you bring it?
No, that is a different aspect of the matter.
Understood. There also he is asking,
No,
they are asking
In
for.
that case, Lordship, there is a law that if the seller has not paid the tax, then department can proceed. However, department to make inquiry whether this seller or purchaser were genuine person or not. That is a different aspect of the matter. And this about 15 or 16 cases are pending before this novel court also, before division bench court.
That is a case of challenge to section
Section
16(2)(b),
Yes, sir.
which is not that. He's not challenging that. His simple case is that I have submitted my return done, everything is done. You issue a notice after the period is over, before the period, but passes on order subsequently. Isn't that your case, Mr.
my
Jain?
lordship.
That is it.
Even notice is issued after the period.
Huh?
Even notice is issued after the period has left.
His notice has been issued after that. Then
I've not gone through a particular case, Lordship, because it's coming for first time.
everybody has a different case.
Then, Lordship,
Her case is of 16(4). She can get the benefit under 16(5). But her only anxiety is that you may not bring the law. And tomorrow, if you take any coercive action against me,
Yes, Lordship, till the acts come into force, Lordship may provide that we are not taking any action against them. And no order has been passed after 53 council recommendation. Lordship may take my undertaking, Lordship may reflect in the order also.
what?
That we are not going to take any action till the act is passed under section.
And as regards the other petitioners who have other things which have nothing to do with the finance act.
Then we have to examine each and every case.
Secondly, 128A of the new finance bill,
Yes, Lord.
where they have inserted 128A, brings a provision that if there is a pending appeal or a writ petition, they are not going to get benefit. How do you take care of that? Where's the finance bill?
I have next it.
I've given a copy.
My compilation
also
page
last
number 53.
See?
Starts from page 53. The entire CGST portion I've given. A is at page 65.
128A, clause 3. Nothing contained in subsection 1. Subsection 1 says, notwithstanding anything to the contrary contained in this act, where any amount of tax payable by any person chargeable with tax in accordance with a notice issued under subsection 1 of section 73, or a statement made under subsection 3, or where no order under section 9 has been issued, an order passed under subsection 9 of section 73, and where no order under subsection 11 of section so and so or remand has been passed, an order passed under so and so pertaining to the period from 1st of July to 31st of March 2020, or a part thereof, and the said person pays the full amount of tax as per the notice or the statement or the order preferred under subsection case may be on or before the date as may be notified by the government on the recommendation of the council, no interest under section 50 and penalty under this act shall be payable, and all proceedings in respect to the said notice or statement as the case may be shall be deemed to be concluded subject to such condition as may be prescribed. 3 says, nothing contained in subsection 1 shall be applicable in respect of cases where an appeal or a writ petition filed by the said person is pending before the appellate court or the appellate tribunal or the court, as the case may be, and has not been withdrawn by the said person on or before the date notified under subsection 1. Then how do you say that they will get the benefit?
You have to withdraw the case.
Hmm?
You have to withdraw the cases.
Yes.
And
And
also
you
to
give
pay
an
the tax.
undertaking.
And also to pay the tax also.
Huh?
And also to pay the tax.
Pay the tax. They don't want, Mr. R.S. Mishra is clear. That I don't want to pay a single penny to the government. I will do all my business, do all GST business, but I won't pay. Why won't you cancel his registration?
There is a provision in law for cancellation. Provision under the provision of the GST Act, how a registration provision is there.
Why you have not cancelled his registration if you have not paid?
No, see, some cases are relating to state GST.
Huh?
So Mr. Ravi Mitra is relating to state GST.
Which है?
State GST, state.
No, we are not concerned. These are not state.
Yes, some cases are relating to.
These
state.
cases are state.
Yes.
Lordship, all the cases are for both center because whenever a demand has been issued, it's issued for both CGST as well as SGST. It is only that some of the assessees are mapped to state jurisdiction and some are mapped to union jurisdiction. But demand is for both. Demand is for both.
But where is the notification for the state?
In fact, the state has not issued any notification for
That
extension.
has to be clarified by learned.
Not adopted.
That aspect is to be clarified by.
Where is the state? Very well. Which case is for state?
Item
12 is, tell me the number. I don't have this here. Huh? 3585. It is a state.
Yes.
And there is no notification. Then it's beyond the time.
They have not even adopted. This notification they could have adopted 56/2023. They have not even adopted. I have also stated what my.
And is it your case that the state has not notified?
Yes, Your Lordship.
Huh, Mr. Mishra? Where is your statement in your petition? So here you are challenging the impugn order of this, huh? And only one case of state?
Many cases are.
Your case is also of state. And there is no notification.
It's specific, Lordship. They are saying that it's properio vegre applicable to them.
Huh?
That they on the very first day, like first case was moved earlier because it was these cases are going on for the last 4-5 months. First time when the case was moved, this was the question from the court. Then they said that all the notification are proprio vegre applicable to them. But Lordship, these are not proprio vegre applicable to them. They have to issue a notification, either a notification or
Where is this? Where is do I get the Assam GST Act? I have not seen a copy of it.
Provision are same, Lordship.
provision as no Lordship.
Maybe
But there is a
there will be a 168A was brought in. Let us see how is it.
Lordship section 11(4). Which is not there in the CGST Act. It's only there in the Assam Goods and Services, section 11(4).
11.
It's only in respect of exemption that they can borrow the notifications of center, but otherwise they have to issue a fresh notification for their cause of action.
11(4).
What notification?
Any notification issued by the central government on the recommendation under subsection 1 of section 11 or order issued under subsection 2 of the said section, the central layers shall be deemed to be a notification again. What is 1 and 2? That is why the public interest to do. So only subsection 1 and 2 will appear. And this has nothing to do with 168.
Yes.
And there is no 168 in this.
It is
So we
there.
have to adopt this.
Huh?
It is there. It is there. 168 is there in State Act also.
168 is there, they can pass.
In the
But they have
State
to
Act.
issue a fresh. Yeah, but they have to issue a notification under that act.
Where is 168A?
It will not be there because in this lordship. book,
Where will I
not
get
be
it?
there. It's old book lordship, it will not be there.
Where is the new book?
notification came in 2020.
Huh?
The new notification came in 2020, September 2020.
Where is that?
Lordship, I have lordship in the compilation lordship.
You have
which I
given?
Yes, lordship. From the Assam taxation.
Taxation of Laws Relaxation Amendment Act 2000. That is it, or no?
Page
Of the
49.
GST Act portion of the finance bill. Where?
Lordship, it's page 49. It starts from page 49. Relevant portion is at
Page
51A.
49.
51A. How it was inserted.
Okay. 168A. Now, this is the Central Act.
Central Act.
Now, is the state, where's the State Act?
That I have to find also whether you know. Don't know.
Huh?
What state also I have to find.
State Act?
Lordship, that is a admitted position they have not adopted. But neither have they issued any notification.
No, no, no.
nor
Then
adopted.
one has to see that the order will be there that the central government will or the state government will pass.
Oh.
So if that is be so, the state government has to pass an order,
Yes.
a notification. If they have not issued the notification, obviously these things will go.
They can also talk to also lordship. That also they have not done.
We do one thing. As there are two aspects of the challenge. One is on the question of force majeure, and the other is there, but it's a point of law. We issue a short notice to them because without giving them an opportunity of replying, and if I allow it, tomorrow they will go to the division bench and raise that issue only. Isn't it? So under such circumstances, let me think. But 168A, if I could got it somewhere, which notification? Because that provision, then I will incorporate it here, na? That there is no notification issued in this regard. Issue notice. This is a case of 3585 is a case of state GST. Okay. Issue notice making it returnable on 19th of August. File your whatever affidavit you have to file.
And put the central works. And put the
No,
central.
no, anyways. Issue notice making it returnable on 19th of August 2024. Full stop.
37 plus. 728 any book.
Mr. You are there in this case also 3585. Mr. S.C. Kyle represents the respondent numbers 1, 2, and 3. Full stop. Mr. Who appears for 4 and 5? You. Mr. H. Bulwa appears for the respondent numbers 4 and 5. Taking into account that the respondents are duly represented, extra copies of the writ petition be served upon them by tomorrow, by 2/8/2024. The challenge made in the instant writ petition Mr. Mishra, why are you challenging 56 here? Huh? No, this is state. Why are you challenging 56?
No, my lordship, what happens that there is a demand of both SGST and CGST. So even though if it's an officer of a state, but he issues an order under CGST Act also. So that there is a cross empowerment is there. So that's why it is
In
relevant.
the instant writ petition, the petitioners have assailed the action on the part of the Central Board of Indirect Taxes and Customs in issuance of a notification number 56/2023, their central tax dated 28th of December 2023. The challenge to the said notification, broadly speaking, are for two reasons, two grounds. First, that the said notification so issued by the Central Board of Indirect Taxes and Customs is ultra vires section 168A, capital A, of the the CGST Act 2017, on the ground that there is no recommendation of the GST Council which is a mandatory requirement for the purpose of issuance of the said notification. Referring to the judgment, referring to the various provisions of the GST Act, as well as the 49th meeting of the GST Council, the learned council submitted that the GST Council had made a recommendation only for the financial year 2017 and 18 up to 31st of December 2023, semicolon, for the financial year 2018-19 up to the 31st day of March 2024, and for the financial year 2019-20 up to the 30th day of June 2024. In pursuance to the said recommendation, a notification was issued dated 31/3/2023 by the Central Board of Indirect Taxes and Customs. Full stop. Thereupon, the GST Council have not granted any further recommendations till date. And in spite of that, the Central Board of Indirect Taxes and Customs have issued the notifications dated 28/12/2023, thereby extending the period to pass the order under 73(9) of the CGST Act 2017 for the financial year 2018-19 up to the 30th day of April 2024, and for the financial year 1920 up to the 31st day of August 2024. Drawing the attention of this court to the provisions of section 168A, the learned counsel appearing on behalf of the petitioner submitted that without the recommendation, the government cannot issue the notification for extending the period under section 168A of the CGST Act 2017. And as such, the said notification number 56/2023 Central Tax dated 28th of December 2023 is ultra vires the Act, the CGST Act 2017. In addition to that, the learned counsel submitted that even otherwise also, the said notification cannot stand the scrutiny of law in view of the fact that the power to exercise under section 168A is conferred only on the basis that there is a force measure. The learned counsel appearing on behalf of the petitioner submitted that it is a case, in the instant case, the COVID period being over, and there being already an extension so granted, and the reasons sought for extension, as could be seen from a perusal of the minutes of the 49th meeting of the GST Council, is that the authorities concerned are not in a position to complete the audit, assessment, etc. Not being able to carry out the audit, assessment on account of lack of manpower, as stated in the minutes, as would appear from the minutes of the meeting of the 49th Council, cannot under any circumstances be said to be a force majeure. Full stop. He therefore submits that the learned counsel therefore submitted that even on this ground, the notification dated 56/2023 cannot is to be rendered ultra vires the provisions of the CGST Act 2017. In addition to that, the learned counsel appearing on behalf of the petitioner also submitted that the government of Assam, that the state exercises the power to collect tax under the provisions of the Assam Goods and Service Tax Act 2017. In the said provision, there is a parameteria provision, which is also section 168A, parameteria provision to section 168A of the CGST Act 2017. In the case of the state government, there is no extension even for the financial year 2018-19 and 2019-20, as have been done by the notification dated 56/2023. Under such circumstances, that the state GST authorities also cannot nullify the provisions of limitation as set out in the Assam GST Act 2017. The learned counsel appearing on behalf of the petitioner submitted that the orders which have been impugned in the instant proceedings are orders passed post 31/3/2024. Full stop. As the very notification by which the power have been extended is ultra vires, the Act of the CGST Act 2017, and there is also no notification in terms under the provisions of the Assam GST Act 2017, the impugned order dated 11/1/26 for the impugned orders in the instant proceedings is required to be interfered with. I've also heard the learned counsels appearing on behalf of the respondents. It has been submitted by Mr. S. C. Kyle, the learned counsel, appearing on behalf of the respondent GST, on behalf of the respondent CGST, that the petitioners herein that that there is no the learned counsel submit that there is no the SCKL, the learned counsel appearing on behalf of the CGST submits that there is no recommendation in so far as issuance of the notification dated 56/2023, dated 28/12/2023. However, in view of a recommendation so made by the GST Implementation Committee, and there is no GST Council and committee, the said notification dated 56/2023 CT, dated 28/12/2023 have been issued. The central government is further taking steps for the purpose of getting the GST Council ratification, which is yet to take place. He, however, submits that in view of the new Finance Bill 2024, whereby various amendments have been suggested and would likely to be brought into the statute books by issuance of necessary notifications, the petitioner herein would be entitled to all the reliefs so sought for. In that, Mr. Kyle, you'll be entitled to all the reliefs. And entitled to the reliefs insofar as the assessment proceedings are concerned. However, he submits that the said the notifications bringing the enactments are yet to come into force. Mr. B. Gogoi, appearing on behalf of the Assam GST Act, submitted that the council, that the Assam GST, the authorities under the Assam GST follows the notifications which have been issued by the central GST. And as such, the said notification dated 56/2024, 2023, dated 28/12/2023 shall also be applicable insofar as the Assam GST is concerned. Per contra, the learned counsel appearing on behalf of the petitioners submitted that in the instant case, submitted that the Assam GST, the provisions of Section 11 of the Assam GST Act 2017, only 11(4) of the Assam GST Act 2017, only permits that certain notifications which relate to section 11.1 and 11.2 of the 11.1 and 11.2 of the Assam GST Act 2017 can only be adopted. Full stop. The Learned Council submits that a notification granting an extension is never conceived of in section 11.4. Full stop. This court, having heard the Learned Councils appearing on behalf of the parties, is of the opinion that it prima facie appears that the impugned notification dated 56/2024 is not in consonance with the provisions of the Central GST Act 2000, provisions of section 168A of the Central GST Act 2017. If the said notification is set aside, if the said notification cannot stand the scrutiny of law, all consequential actions taken on the basis of such the said notification would also fall. Full stop. This court also duly takes note of the submission of Mr. S.C. Kayal that the petitioners herein would be entitled to the reliefs post the enactments being brought into as proposed in the Finance Bill 2024. Under such circumstances, this court, in addition to that, this court also finds that an examination will be required as to whether as regards the applicability of the force majeure clause in the instant proceedings, in respect to the notification dated 56/2024, taking into account the contents of the minutes of the 49th meeting of the GST Council. However, for the purpose of deciding the same, it would be required, this court is of the opinion that an affidavit would be required from the concerned respondent authorities. This court is of the opinion that an opportunity has to be granted to the respondent authorities to make their place on record the materials on which they claim that the applicability of the force majeure clause. Full stop. Accordingly, full stop. Taking into account the above, this court is of the opinion that the petitioners herein are entitled to an interim protection pending the notice. Accordingly, this court stays the impugned order. Kindly give your dates, sir. Impugned order of assessment orders passed under section 73 of the orders passed under only one order under section 73. Both has section 73. Same.
Of the GST Act.
Okay, section 73 of the passed under section 73, which relate to the financial years 2018 and 19 till the next returnable date. Full stop. The respondents are directed to file their affidavit on or before. When did I fix it?
19.
28. 22. Okay. 22. No, not 22. This is not a matter. 21st. 21st. I have fixed it. Filed their affidavit on or before 19th of August 2024. Give your date numbers, impugned orders.
Just one small point, my lordships.
Huh?
Just one small point, my lordships, regarding the recommendation, that what would be the mandatory and what would be the especially section 9 of the CGST Act itself has that, from there itself it is clear. As far as the alcohol is concerned, it cannot be, their recommendation from GST Council will not be binding at all, because they don't have the power to demand tax on alcohol. But as far as petroleum products are concerned, it will come from the net.
Mr. Jain, there
Yes.
is one very important point. I hope Mr. Kyle have got it today. That the exercise of power under 279A, 4H, is the power on which 168A has been done. So it would come within any other matters. Now, under such circumstances, whether the recommendation would be persuasive or binding is a very important aspect. And that too, when they have sought for a recommendation which was rejected. You ask for some more time. Come up with a better affidavit, not this one. It is a very difficult affidavit.
Sent by the board laws.
Huh?
Funds were sent by the board.
Hmm?
The BSc board laws. That basis of recount, their price, this affidavit was. I'll take more time, maybe refer to I'll better.
Because this is a very important point involved. So, all these matters, similar orders will be passed. All separate orders.
Oh, obliged.
Much
I'm coming. Yes.
Lordship, the item number 5, your lordship. The last opinion told me to mention this item for upgradation by your lordship.
We'll take it up after this. Yes, what is this?
The circle officer had issued a notice on 1/6/2024. Wherefrom it appears the respondent number 5 had filed an objection to my application for seeking sale permission of the land. And accordingly, I was asked to submit the objection. I have filed the objection. Now recently, without the passing any order, a separate notice has been issued again on 8/7/2024. That too, not to me, but to the officer in charge of the police station. That the demarcation will be done on 3/8.
Then what happened? You filed a written objection.
Yes, I have filed the written objection.
Then?
No order has been passed. Now again, I have come across a notice that has been issued to the officer in charge fixing 3/8/2024 as the date of demarcation. I came to know about that, so I have approached this court. From the notice, it appears that the respondent number 5, she is not the recorded patara. And in the objection also, I have submitted that the possession of the land under my possession has been confirmed by a decree of this competent civil court. Firstly, the respondent number 5 should have the locus to file any objection to my sale permission, or even for demarcation, she should be a recorded patara.
And what do you want?
The notice to be state the demarcation.
Why? Who is in possession?
I'm in possession.
Okay, let them carry out the demarcation without disturbing your possession.
One thing, the nature of complaint, the person concerned, the respondent number 5, for the purpose of demarcation, she should be the recorded patara. Doesn't have, she is not the recorded patara. Then, in fact, this has been my third occasion. Earlier also, I had to file the civil suit because of the disturbance caused by the other person. So decree had been passed. Thereafter, again, another attempt was made by another person. That again, I have submitted the objection. That was stopped there. Now again, the third person it has been come. These all have been started after the death of the husband of the petitioner number 1.
No, maybe has she purchased the land?
No, nothing. She is not even a recorded person. She doesn't say. Even the complaint has not been furnished to me. You can see the Jamabandi.
So you have filed your written objection in the year 2023. When did you file?
28/6/24, my lord.
Then what happened?
But I have filed on 15/6/24, my lord.
Hmm.
No order has been passed on that.
Huh?
No order has been passed. For the present, my lord, notice has come, my lord, at page 86. It's also not addressed to me. From the bottom, it appears, my lord, it has been issued to the and the officer in charge, my lord, that the demarcation will be done. About, my lord, the circle officer should ascertain, my lord, she is the recorded pattern, my lord, what locus he has to, my lord, make in my lord, demarcation, my lord, so far as my land is concerned.
Hello? We issue a short notice. It is there on 380. Why have you come so late?
But this notice is not addressed to me. Recently, my lord, I have come to know.
Huh?
Notice is not issued to me.
To the Pattadas, you are not none of it.
No, my lord.
Huh?
It has not been issued to us.
You are in possession.
I'm in possession. Possession has been confirmed by decree of the civil court.
Notice is issued to the Pattada.
Page 86 is the notice, my lord.
Page
Huh?
80, Lordship may be pleased to see page 86 of the writ petition.
Ah.
Page 86 is the notice. Down below, Lordship will find in the second paragraph, Pattadars of Dag number so and so and the Patta number so and so, serial number 5. Tiken Chandra Bayan. Now, Tiken Chandra Bayan is the husband of petitioner number 1 and father of, this is father of petitioner number 2, 3, and 4.
Sorry, sir.
So that is how you came to learn.
Although this has been issued to the my lord office. Lordship
Let
said
the
of-
demarcation go on. No disturb to the possession. You are in possession. So how are you bothered? I'm protecting your possession.
One more thing, my lord, the at least copy of the complaint that you furnished, that has also not been given.
So application for demarcation only.
So it is not an application for demarcation. Notice itself when it says that she has objected to the well, the application.
That is one another thing. There must have been a sale deed done in the meantime, I suppose. You never know. Get your information correctly. Something must have happened in the meantime. Otherwise, why will they issue?
But that is the my lord, whole my lord, ground I have my lord, mentioned in the my lord, objection petition also.
Anyways,
But-
you are in possession.
I'm in position.
You remain in possession. They won't disturb you. Let them go and demarcate.
Phillips may be directed to give me the my lord, copy of the complaint at least to know me.
Have you asked the circular?
I had visited the office, my lord. I had-
Where? Where is your application? No application. Oh, issue notice making it returnable on 28th of August 2024. The Arbor Pujari appears on behalf of the respondent number 1. Kusami appears for the respondent number 3 and 4. As taking into account that the respondent numbers 1 to 4 are duly represented, extra copies of the writ petition served upon them. Okay. As regards the respondent number 5, the petitioner is directed to take steps by way of dusty as well as by raised post. AD within 3 days. In addition to that, the petitioner is also directed to effect service by way of dusty. And as regards the respondent number 5, steps be taken by way of dusty as well. Be taken as by registered post with AD as well as by dusty, as well as by usual process within 3 days. In addition to that, the petitioner is also directed to effect service upon the respondent number 5 by way of dusty, routed through the registry of this court and file an affidavit of service. And the case of the petitioner herein is that the petitioner are owners of a plot of land. Are you owner? Where have you mentioned? Are owners of a plot of land measuring 1 bigha 10 katha covered by Dag number 2810 of KP Patta number 1316 of village Udalbakra, Moja, Beltola, in the district of Kamrup Metro, Assam. Where is the decree?
Page, 14.
You purchase a possessory right.
So far as 3.5 katha matlab I sold it.
Huh?
3.5 katha I sold it. And there's
No,
certain.
why the decree is not for declaration of your right title interest?
These were, the title was not questioned, she tried to dispossess.
You have purchased only the possessory right.
No. Two sold it,
The suit is thus decreed, ex parte plaintiffs are entitled to the declaration that the plaintiff and the performer have a right to use and occupy the suit land, confirmation of possession of the suit land, and so and so. Why there is no declaration of your title?
The title was, there's no question to the title, so
Huh?
they tried to disturb the possession only, so therefore only the confirmation of possession was sought from. Till did I have annexed,
No. Kindly see page 59. Why did you file the suit? That the above illegal actions of the defendants have clouded the right and title of the plaintiffs upon the suit land purchased by their predecessor upon their possessory rights of ACP land in their possession
There's
since
one
more
plot
than
is there.
32
One-
years.
One portion of the plot, two kathas, that is of
But
the
this declaration is only as regards possession. This is not a declaration of your right title interest.
the title, there was, as such,
Then-
the title was not clouded, so therefore, the decree was not
The
supported.
the case of the petitioners herein is that the petitioners are the recorded pattadar, are the daughters of a recorded pattadar, one Tiken Chandra Bayan, in respect to a plot of land measuring 1 bighah 10 lechas covered by dag number 2810 of KP Patta number 1316 of village Udalbakra, Moza, Beltola in the district of Kamrup Metro, Assam. It is seen that the petitioner numbers 1, 2, and 4 had filed a suit against one Makhoni Bala De, which was registered and numbered as title suit number 421/2018. The said suit was decreed ex parte by the judgment and order decree dated 5/5/2022, thereby declaring that the plaintiff and the performer defendant had right to use and occupy the suit land, confirmation of possession over the suit land, and permanent injunction restraining the defendant therein from interfering with the peaceful possession of the plaintiff and the performer defendant. Gustav. Thereupon, on 18/5/2024, a notice was issued to the pattadars of dag number 2810 and the patta number 1316, to the pattadars of dag number 2810 and 2814 and the patta number 1316 for their appearance before the Circle Officer, Dispur Revenue Circle, in view of the fact that the permission for sale, in view of the fact that the sale of the land covered by dag number 2810 and 2814 under KP Patta number 1316 of Udalbakra under Beltola Moza have been withheld on account of certain objections, and accordingly directing the said pattadars to appear before the Circle Officer, Dispur Revenue Circle. Pursuant thereto, the petitioner submitted an objection Subsequently, on 8/7/2024, another notice was issued to the pattadars of dag number 2810 and 2814 and the patta number 1316 in connection with miss case number 480/2023. To the effect that, in connection with physical measurement of the land covered by dag number 2810 and 2814 under KP Patta number 1316 of Udalbakra under Beltola Moja. It was informed to the pattadars to be present on 3/8/2024 at 11 a.m. for carrying out the physical measurement. The said notice dated 8/7/2024 has been put to challenge before this court. Mr. P.J. Shaikia, the learned senior counsel, appearing on behalf of the petitioner, submits that the petitioners are in possession of the plot of land measuring 2810, measuring 1 biga 10 lechas in dark number 2810 of KP Patta number 1316 of village Udalbakra and the Beltola Moja, and apprehends that while carrying out the said physical measurement, the petitioner's possession may be disturbed. And as such, has approached this court. In addition to that, the learned counsel further submits that the respondent number 5, at whose instance the Miss Case number 480/2023 have been initiated, is not a recorded pattada, and as such, the said proceedings could not have been at all initiated. This court is of the opinion, and this court have also heard the learned counsels appearing on behalf of the respondents. It is the opinion of this court that if the petitioners are in possession of the land measuring 1 biga 10 lechas covered by dark number 2810, 1014, 10
281.
of KP Patta number 1316 of village Udalbakra under Beltola Moja, the respondent authorities, more particularly who are the revenue authorities, cannot disturb the possession of the petitioner. However, it is made clear that the respondent authorities can carry out the demarcation, can carry out the physical measurement. Under such circumstances, this court observes that till the next date, observes that the observes and directs that the respondent authorities may go ahead with the physical measurement in terms with the notice dated 8/7/2024. However, under no circumstances shall disturb the possession of the petitioners if they are in possession of the petitioners over the land in question. The said interim order shall continue till the next date.
The attempt of the circle officer to private persons. This is the third attempt that has been made.
Therefore, I have protected your possession.
This is already there under the demarcation.
Demarcation only, Mr. Saikia. Demarcation only, they create all the problem.
So therefore, they're just trying to enter into it.
They cannot. I made it clear that they would not disturb the possession of the petitioners over the land.
Whether they could have initiated the proceeding at all, my lord, that is not.
We'll look into it later on. Let them go ahead. You also be clear that this is your plot of land.
Recorded owner of only my lord. But how plan, Gama Pandit. Next, how he came into position where from he has purchased, the petition is silent.
This is mentioned clearly, my lord.
Item 5 upgraded. I'm obliged.
Yes, what is this?
My pleasure, sir. Lordship, I have filed affidavit in reply against the undertaking filed by the appellant side.
What is your reply?
Party has objection.
What objection?
May I pay to go into the merit of the case?
What?
Merit of the case.
Very well. I am going into the merit of the case only. That is the I only ask them to file an undertaking to that effect only for the purpose that prima facie case, that balance of convenience is duly taken care of. That is why this undertaking is there. Matter over. Let them go ahead and construct. La hawk.
Some vital materials are there. If you Lordship allow me only 5-10 minutes time.
What?
Some vital materials are there.
What vital matters?
Lordship, initially dispute starts with the tenant, and tenant also filed a suit before learned Munsif number 1, and learned Munsif 1 also considered interim order temporary injunction. Lordship. Initially that was violated, which compelled me to prefer next suit, that is title suit number 92 of 2013 for declaration of right title interest as well as confirmation of possession. During pendency of the suit, I was dispossessed, and then I filed an application under Order 6 Rule 70 for inserting certain facts as well as to insert prayer of recovery of possession. And thereafter, the learned court bureau, considering all those aspects, to grant injunction order to preserve and protect the subject matter of the suit. Lordship. So if at this stage, Lordship, they are allowed to construct purpose.
So they will demolish it. They'll demolish it. They've given an
During
undertaking.
pendency of the suit, that materials are there. If your Lordship allow me to show all those materials,
No.
I will take 5-6 minutes time, Lordship. They're continuously doing all illegal in spite of having injunction order of 2 courts, Lordship. One filed by the tenant and another filed by present respondent. That materials are there, Lordship.
He has purchased the land.
26.
Lordship, actually, my source of title is not inheritance right. Based on oral partition, my predecessor left total 5 properties. Out of 5 properties, respondent, that is plaintiff to the original suit, got 2 plots of land. So my source of title based on oral partition. Not
You are the, well, how much is your share?
2 plots of land I have described.
No, share. Share, what is your share?
Schedule A land and Schedule B land.
Share, as per the land, how much?
Entire schedule land and entire.
How much that the daughter gets?
That's it.
Only 1 cut of 4.2 by 3 lesson.
Matter
Out of 3 cut of 4 lesson.
My
And here
my claim of title is not based on inheritance, oral partition.
Suit is of the year.
So I am entitled
2023.
entire schedule A and B property.
Understood. You will prove your oral partition. Prove it in the court. Until then you give an undertaking. You indemnify him for all the costs. You don't want to do it. Nothing
Merit of the
doing.
case and then come to.
Civil courts litigations are not so easy nowadays. You get an injunction, stop everybody, and this case will go for 110 years or 15 years, and then one fine day, during his lifetime, he would not be able to enjoy his
In
cross.
time in time.
Nothing
demo
doing.
is
What
all
were you
my
doing all
source
this
of-
while when the sale deed was executed? You
I
were
am
sleeping all
challenging
this
that
time?
sale deed. I am challenging that.
When
sale
did the
deed.
sale deed execute?
6/2022, your lord.
And 2/6,
2022.
2022. And when did he file the suit?
Suit on lordship,
23 law.
yes, 31 of 23. After process of the
Immediately
land
after
by
coming
me,
to knowledge.
after process of the land by me, well, I was in possession. That is 31 of 23, your lord.
Thing doing.
So-
Defendant has contradictory statement. Initially, they filed written statement in tenancy suit seeking some other defense, and then before learned civil judge number 1, they took another defense, and before your lordship in FAO memo of appeal, they took another defense. That itself crystallized their malified intention. I also have written from report to lordship. Allow me to.
Heard Mr. S. Ali, the learned counsel appearing on behalf of the appellant. Mr. R. Ali appears on behalf of the respondent. An appeal under order 43 rule 1R of the Code of Civil Procedure challenging the order dated 23/2/2024 passed by the learned trial court, that is the Court of the Civil Judge Senior Division number 1 Kamrup Metro at Guwahati in case number 1188/2023 in title suit number 92/2023, whereby the learned trial court directed that both the parties to maintain status quo over the Schedule A and B land until the court conclusively decides the suit. At the outset, this court would like to opine that the order by which both the parties were directed to maintain status quo over the suit Schedule A and Schedule B land is a completely vague order which the trial court ought not to have passed, taking into account that an order of injunction if passed has to be specific. Be that as it may, this court for the purpose of deciding the instant appeal would like to take note of the facts involved which led to the filing of the instant appeal. The respondent herein, as plaintiff, had instituted a suit taking declaration of right title and interest, confirmation of possession, cancellation of the deeds, and the permanent injunction. The said suit was filed on 13th of February 2023. It is the case of the plaintiff in the suit that she is the owner of a plot of land measuring 1 katha 19.85 lechas covered by DAG number 1784 and 2326 of KP Patta number 303 of village Sohor Guwahati part 1 under Moza Beltola, under Moza Guwahati in the district of Kamrup. The said land have been specifically described in Schedule A to the plaintiff. In addition to that, the plaintiff also claimed that she is also the owner of another plot of land measuring 1 katha 4.37 lechas covered by DAG number 154 and 2205 of KP Patta number 303 of village Sohor Guwahati part 1 under Moza Guwahati in the district of Kamrup Metro, Assam, along with the standing houses. The said land has been described in Schedule B to the plaintiff. It is the case of the plaintiff that there were 5 properties belonging to the father of the plaintiff and father of the plaintiff, one Jamiruddin Ahmed, to the parents of the plaintiff, that is one Jamiruddin Ahmed and Ismat Ara Ahmed. it is the case of the plaintiff that the Schedule A and B properties, or after a amicable partition with her brother, fell into her share, whereas the properties described in Schedule C, D, and E fell into the share of her brother. However, the brother, by the registered sale deed bearing deed number 12594/2022, and one sale deeds numbers 12594/2022 and sale deed number 12595/2022, both dated 2/6/2022, sold the land to the defendant number 2 in an illegal manner, and did you amend the plaint?
Yes, Lordship.
This plaint?
Yes, I have amended, Lordship.
And as such, and yeah, Kusto, it is the further case of the plaintiff that the plaintiff apprehending that now the defendant number 2, who is the appellant herein, would dispossess the plaintiff had instituted the suit taking declaration of right, title, and interest over the Schedule A land for confirmation of possession of the plaintiff and her tenants over the Schedule A land, and for declaration that the sale deed numbers 12594/2022 and sale deed number 12595/2022, both dated 2/6/2022, are void illegal documents, and for other consequential reliefs. Good stop. Where is your amended plaint?
Lordship will find affidavit in opposition filed in IA number 1530. Page number 74, Annexure G.
Page?
Page 74. Affidavit in opposition filed in IA 1530.
Subsequent thereto, the plaintiff was dispossessed from the Schedule A land.
Paragraph 13A,
Schedule A land or what?
A land. Lordship.
Huh?
Schedule A, paragraph 13A, amended part, and page 83.
Schedule A land, A or B?
A, Lordship, only A. Subject matter of the suit
Schedule
basically
A land. And accordingly, the plaintiff sought amendment of the plaint
the prayer of record.
where is the plaintiff?
Then prayer person, Lordship, will find at page number 86.
Huh?
Page number 86.
It's 86 prayer person, your lordship.
Recovery of possession in place of confirmation of
Have-
possession, prayer
Have
number B.
amended the plaint, thereby seeking recovery of possession of the Schedule A land by ejecting the defendant, their men, materials, constructions, etc., and including, and in addition to that, claiming compensation. Full stop. Did you file an application for an injunction after that?
Yes, Lordship.
Where is that?
Immediately after disposition. That is part of the FAO, Lordship.
Huh?
That is part of the FAO.
Yes,
main
where?
case. But you will find at page number 53 of appeal.
Pursuant thereto, post filing the amended claim, an application for injunction, a fresh injunction application was filed, being Mizze case number 1188/2023. Seeking an injunction, thereby restraining the opposite parties who are the appellant herein from changing the nature and character of the Schedule A property or any part thereof, or also not to create any third party right interest of the Schedule A land in the interest of justice. Full stop. Written objections were filed to the said application, and pursuant thereto, the impugned order was passed. Full stop. The learned counsel, Mr. S. Ali, the learned counsel appearing on behalf of the appellant, submits that there is no materials on record that the Schedule A land, A and B,
Basically, subject matter of the schedule A, schedule A.
In all these schedules, your lordship, hard name does not appear in Patta. Not a single document. Revenue record.
submits that the plaintiff has no semblance of any right over the suit land. Merely, the plaintiff asserts on the basis of an oral partition that she has right over the suit land, whereas in all the revenue records also, the name of the brother of the plaintiff appeared in all the Schedule A, B, C, D, and E lands. Mr. Ali further submits that the plaintiff herein, that the appellant herein, after making due verification, have purchased the said suit plot, Schedule A land. The learned trial court did not appreciate the fact that the plaintiff could not show a single piece of document to show that there is any prima facie case involved in the suit. In addition to that, the learned counsel appearing on behalf of the plaintiff appellant submitted that granting an injunction has to be on the basis of the three golden principles. Merely because there is a prima facie case would not be enough for grant of an injunction unless and until there is a consideration as per consideration so made as regards the balance of convenience as well as the irreparable loss, harm, and injury. These aspects of the matter were not taken into consideration by the learned trial court.
Not discussed also.
As well, consideration and even discussed by the learned trial court. On the other hand, Mr. R. Ali, the learned counsel appearing on behalf of the petitioner, plaintiff submitted that the plaintiff had been all along in possession of the Schedule A and B plot of land. In respect to the Schedule A plot of land, the plaintiff had tenants, and these tenants were evicted by the appellant without following due process of law, and that too in violation of certain injunction orders. He further submitted that At the time of filing of the suit, the plaintiff was duly in possession. However, post-filing of the suit, the plaintiff had been dispossessed, and it is under such circumstances the plaintiff had to amend the suit seeking recovery of possession. He further submitted that the facts on the basis on which the plaintiff, the appellant, has approached this court for grant of an injunction, for vacating of the stay order, vacating of the injunction order, is does not. He further submitted that the appellant herein, in view of his conduct, in its conduct, is not entitled for challenging an order passed for granting injunction, which is an equitable jurisdiction exercised by the learned trial court. Anything more?
What happened in their written statement? They only denied my relation with my brother. I have submitted certain document to show my relation with Jasim Raja, that is vendor to the appellant side. That was considered, Lordship. That is also part of this FAO from page number 263.
And anything more on an injunction matter? This court, while taking up the instant appeal on an earlier occasion, put a specific question to Mr. S. Ali, the learned counsel appearing on behalf of the appellant, as to why the appellant wants vacation of the order, taking into account if the appellant is in possession, the status quo order so passed by the learned trial court would be in his favor, in favor of the appellant. The learned counsel submits that the appellant had duly purchased the suit land by paying a valuable consideration. Under such circumstances, the appellant wants to construct a develop a residential building.
Plus commercial, your lordship, because it is a
develop the said property so that the appellants develop the said property. Also, under such circumstances, this court posed a quite specific query upon the learned counsel appearing on behalf of the appellant as to the appellant, that if any development is made to the land in question, it would result in changing the nature and character of the suit land, and thereby it would become very difficult on the part of the plaintiff later on to execute the decree. In the circumstance, the decree is passed in favor of the plaintiff. Under such circumstances, Mr. S. Ali duly submitted that he would submit, that the appellant is not adverse to submitting an undertaking before the court, that in the circumstance, the suit is decreed in favor of the appellant, of the plaintiff. The appellant would hand over the possession of the land as well as the building in favor of the appellant, in favor of the plaintiff, and would also not create any third-party rights. Taking into account the said submission, this court was of the opinion that it would be in the interest of justice that such an undertaking is made in the form of an affidavit before this court. Accordingly, an undertaking was submitted in the form of an affidavit, which reads as follows. Where is it? Is that affidavit? Undertaking in the form of affidavit. Undertaking in the form of affidavit. Full stop. The said affidavit was filed on 15th of July 2024. Full stop. The undertaking so given is at paragraph number 3, which is reproduced herein under page 270. From a said quoted portion of the above, it would be saying that the appellant herein had given a clear undertaking that he shall demolish any construction made during the pendency of the suit and hand over the possession to the plaintiff in the circumstance the plaintiff succeeds in the proceedings initiated. The undertaking further states that the appellant shall not create any third-party rights over the suit land during the pendency of the suit. Pustak. This court duly takes note of that the said undertaking to be an undertaking given on behalf of who? Who is the appellant? Is an undertaking given who now who is this Joyashree?
This is this property form, your lord.
Huh?
Property,
Proprietarial firm.
your lord.
Sir Ali, the proprietarial firm, can a person be a director?
Let's company, your lord.
Huh?
Private company.
Private company also, it's a director.
He's
Tomorrow you are going to very well come up and say, look here. Oh, I am only a director.
He's very.
My right is only limited to the shares. How can he give an undertaking on behalf? It is a very good ploy.
They have made me party like this, your lord.
Whatever may be, are you a director of this company? Whether this is a undertaking by the company also.
Lordship, on behalf of the company, he has.
Where is it mentioned? I. Everywhere is I.
Your lordship, I have instruction, your lordship.
No business of instructions in a civil matter. Mr. Ali, no instructions. We'll dispose of you. You'll file another one, affidavit. This court have duly taken note of the affidavit which was filed by the appellant number 1 on 15/7/2024. From the said affidavit, it appears that it is an undertaking only given by the appellant number 1, but not the appellant number 2. It is seen that the appellant number 2 is a company incorporated under the provisions of the Companies Act. And as such, this court is not satisfied with the undertaking given insofar as the appellant number 2. So taking into account the above, this court grants another 15 days time to the appellants to file an affidavit giving a undertaking in terms with the order dated 27/6/2024, which would be applicable in favor of both the appellants. Is the matter again on when? How much time? 16th August. You have to give an undertaking in that, and also a board's resolution bring in, because nobody can give it. Tomorrow again I'll put it. Where is the board's resolution? আগৰখিনি ৰাখি দিব, এইখিনি লগাই দিম অফিচত। Yes, Mr. Das, your matter.
It's on item 2 and 3. File an affidavit, the state. If an
Yes, finance. Yes, finance. Did you file an affidavit?
My lord, I am awaiting the instruction. They are taking some further time, my lord. They are working on it, my lord.
Your lordship has heard this matter.
The file is.
Already, they have shown it as part of, isn't it?
That's why further hearing will take place.
I have already duly communicated, my lord, to that extent, my lord, pertaining to my lord's query, my lord. I will be filing an affidavit. Lordship will kindly accommodate me, my lord, for some further time, at least 1 week, my lord.
Mines and minerals is where? Mines and minerals.
PTC, my lord.
PTC.
PTC.
ETC is okay. Huh? Mines and minerals. Where is mines and minerals?
Yes, my lord, it will be forest, I think. Forest.
Forest is a transfer subject.
Mr. Barbudari, irrespective of the Procurement Act, can the problem not be solved by applying the settled principles of law, wherein the Supreme Court have categorically observed that whenever you go, there has to be, whenever you go for a tender, it has to be properly published. Something like in Ram and Sham or something like all these things. they were-
Sham Company.
Ah.
Raman Sham Company, 1985, 3 SCC.
What does he say?
6, 7, para 18, it says.
What does he say? But this point, if I deal with it, it will be good for the purpose of later on this problem which is there in 34 can be taken note of.
Yes, only because of my lord.
There was a mistake. Apparently it shows some mistake.
Only
Otherwise, they
Only because of my lord 34B2, my lord, that word e-auction is.
only mentioned.
So only for that purpose, my lord, lordship had, my lord, expressed some doubt with regard to whether, my lord, because e-auction, my lord, publication of notice has been made mandatory, but otherwise publication.
And that too, when e-auction makes it big, the basis of e-auction must have something foundation out there in the procurement rules. Procurement. And that is the reason why they have incorporated, but forgot to incorporate out there.
But since I have already communicated, the department is working on it, my lord. Lordship will accommodate me for some time to file an affidavit. Let me file an affidavit, my lord. Things will be clear, my
No,
lord.
that would be easier because this needs to be done because the undoubtedly rule permits contract for winning mineral to be granted by the government by auction or tender. It is true that the auction was held. It is equally true that according here, it is open to the state government to dispose of. Even there, here the expression tender does not mean a tender in the means tender to be invited.
Actually, what it says, Article 15, state largesse is concerned normally, it should really given to all the bidders. They should be aware. That's the whole issue, man. Whether
Now,
it must give
if it is
equal
a case of e-auction, it is otherwise also published.
Otherwise also public.
If somebody is into the e-portal,
The very object of my lord promulgating the 2017 Act is to maintain transparency and efficiency in public procurement. And now, my lord, keeping in tandem with the changing times that now technology has changed, my lord. So therefore, my lord, the concept of e-procurement has been, my lord, incorporated. And having that word e-auction appearing in that, my lord, Rule 34, so Lordship has given, made a pointed query to the department. Since, my lord, under that 2017 Act, from time to time, the notifications have been issued by the finance department. And having duly communicated to the department is working on it. My lord, in fact, today morning I had a talk with the, my lord, undersecretary. He said, my lord, that the file is being processed at the office of the commissioner. So very, my lord, soon they are going to give me the instruction. On the strength of that instruction, let me file an affidavit, my lord.
you know, definitely.
Yes,
No,
because
I'll give
finance
you.
is not a party here, but in order to assist the court, my lord,
if your lordship gives a meaning to 34(1) also, but that will be not the basis of the judgment of Supreme Court. If your lordship
also takes into account of 34.1. So let us read separately 34.1. And we don't read 34.2. Even the basis the state largesse is involved.
Now, while carrying out the amendment to the mines and minerals, Assam mines area, was the presidential sanction taken?
That my lord, I am not in a position, my lord, to know, because
Now, if it is then not taken, what happens?
is my lord Assam rules. Of course, my lord, that rules are framed, my lord, under the provisions powers given to the state government in the parent act.
But
Parent,
the rules were made with the presidential sanction.
perhaps I have to check, my lord, because the parent act is a central legislation. And these rules are being framed by the state government. State government, the governor, in pursuant to section 15 of the act, demands Assam Mines and Mineral Development Regulation Act 1957. You see, my lord, Assam Mine and Mineral Concession Rule is power conferred under section 15 so and so Governor Assam hereby make the following rules for regulating the grant of mineral concession for prevention of illegal mining. So under the Parent Act empowers each state to make rules. The state of Assam had made a rule in pursuance to this. Kindly see the first. Page 245. 45.
This is a secondary legislation.
Now these concession rules of 2013, my lord, have been, my lord, promulgated, my lord, in tandem with the provisions of section 15 and section 23C of the
23?
section 15 and section 23C of the 1957 Mines and Minerals Development and Regulation Act 1957. Now section 15 states, my lord, powers of state governments to make rules in respect of minor minerals. In section 23C speaks about power of state government to make rules for preventing illegal mining, transportation, and storage of minerals.
So under such circumstance, there would be no problem with the rules being made. The rules has to be read with the Assam Procurement Act.
Yes, my lord. Now, whether some
Because otherwise BTC comes in view of the definition. Now, if BTC comes in, then they will have to go for procurement.
to that extent, my lord, let me file the affidavit, my lord.
And that I understand. Only thing is, because last time, just before ending, you said that. So I kept on thinking, how is it?
But if your lordship for the forest department, my lord, section 15 and section 23C appears to be the only two, my lord, provisions whereby the state government has been given the power. Section 15 is a positive enactment, and section 23C is a, my lord, preventive enactment. Section 15 says, my lord, 15 says, power of state government to make rules in respect of minor minerals. That is a, my lord, positive enactment. And 23C says, power of state government to make rules for preventing illegal mining.
No,
transportation.
what has happened is this something like that. You see, the union list provides for mines and minerals
Yes,
within it for.
Yes.
So they can't do it by themselves. So what they have to put it, they have asked the government to each state government taking into account to do it. But it would not be a central rule.
not be a central rule. No, because central rules are also there, my lord. I find from
No,
this book.
therefore, in 23C, down below, you find that irrespective of the power being given to the state, the central can also make.
Yes.
Hello, we do one thing. When? How much time?
My lord, any date after 15 August, my lord, with all respect.
What is the finance going to do with the 15th August? Like hosting?
My lord, the assembly session is forthcoming, my lord. All the officers, my lord, of the record I am submitting, my lord. All the officers, my lord, they are.
But here the state is also losing. Your finances, you are losing. Huh?
Yeah,
What are you going to do without finances, the finance department? Or you want to put their BTC in such a position that they are not in a position to only come to you and beg, they kindly give me some more grant because of you.
Because,
Well,
my
at
lord,
the end of the day, they will have to come to you, isn't it, Mr. Bora? Huh? Yeah. The finance is with you.
in the budget, my lord, in the assembly, my lord, the budgetary provisions are to be allocated all because the department is required to make all the permutations and combinations.
When
Right?
do you want it?
Can it be on, my lord? My lord, 28th of August. But prior to that, my lord,
It's only an affidavit to be filed.
let it be on 13th of August, my lord. I will make.
Let's have it on 20, 20.
20, my lord, sufficient time.
This court, by an order dated 18/7/2024, had sought for an affidavit from the Commissioner and Secretary to the Government of Assam Finance Department as regards the interpretation to Rule 34 of the Assam Minor Mineral Concession Rules 2013 in view of the Assam Public Procurement Act 2017 and the various notifications issued therein under making e-procurement compulsory post a particular in respect to certain items beyond a particular limit. Mr. R. Bapujari, appearing on behalf of the respondent, appearing on behalf of the finance department, seeks for some more time taking into account the budget session being approaching, and as such requested the matter be taken up on 28th of August 2024. In the meantime, he submits that the affidavit would be duly filed. So accordingly, list the matter again on 28 2024 at interim order so passed earlier shall continue till the next date.
21st, my lord.
Huh? 2020?
21st.
We want it on 21st. 21st, again, difficulty. Anyways, 21st is a Wednesday. Okay.
But,
Huh?
how is your lordship that this matter?
Taking into account that the matter has been heard at length.
I am so obliged for the accommodation. my lord.
Item 4.
Yes.
Lordship. Here, my lord, the petitioners are on apprehension of eviction, my lord.
Matter pertains to
My lord. Apprehension of eviction, my lord.
apprehension of,
Eviction, my lord.
you've been
They may
evicted.
be evicted, my lord. There was a general notice hang up in the office of the Goalpara Forest Division, my lord. But you will find in Annexer 1, the general notice that there will be an eviction. Because of that, my lord, they are apprehended.
All encroachers of the forest land that who are residing in forest land making residential houses here, they are notified to be vacate the forest land very soon. Now,
My lord, they are not, they should not be treated as an encroacher because the government has allowed them to stay on the land. There is an order of 1964, my lord. That's, my lord, the petitioner village are majority of the.
particular care should be taken, therefore be
of
taken to
Pakistan.
prevent him.
Therefore, my lord, they may not be termed as the order. Lordship may kindly have a look at the order at Annexer 24. The paragraph 23, paragraph 3, page 25 is relevant. Although, my lord, they are allowed to stay.
You are all tribal people.
Tribal people. Majority are the tribal and there are some OBC also. Majority of the tribal. My lord, Hajong and Rabba.
Yes, what is your stand, Mr. Botagur?
Lordship, in our affidavit, we have pointed out that the eviction process had to be initiated in pursuance of Lordship contempt case suo moto 3 of 2023,
Then what happened?
which was stacked together and being heard by the division bench. Lordship. And after that, now Lordship, the cases have been reassigned to single benches, and the forest department is directed to clear out encroachers from the Kumarkhali Reserve Forest, Lordship.
Yes, sorry.
They,
My lord, they are not in Kumarkhali. They are
There is
in
a division bench order.
there is a division bench order, Lordship.
Then why this matter was segregated? The division bench ought to have disposed it of there. On one hand, the division bench passes an order that throw these people out. And this matter should have been taken. That is why it must have been referred there.
Perhaps, Lordship, because the cause of action is a bit different. Here, Lordship, it was initiated by through through the court because of there being reports of encroachment in the reserve forest in Walpara division. And this one, Lordship, the petitioners are now were seeking protection from the reserve forest. And when all of them were clubbed together before the division bench,
Now, this is a reserve forest.
they are in reserve forest, Lordship.
Reserve forest.
my lord,
Reserve forest. How can you have an settlement? Is it possible? No.
Exactly, Lordship. That is what we have contended in the affidavit.
my lord, there has
Why,
been,
Mr. Botakur, what happened to that matter? Some Kahilipara or something, I passed an order as reserve forest or something, it was there. Near Kahilipara, this land has happened. Mr. M. Nath was appearing. The forest department. These were all these lands. They had big
my
houses
lord,
out
the
there.
reason, my lord, I think, my lord, the division bench is saying that to the single bench because there was an affidavit filed by the respondent number 5 and they have stated that there was an inquiry and some delays are detected for carrying out eviction and the petitioner delays are not belongs to that
Your case,
Yes,
that case.
yes, sir.
But that case, there was categorical findings from the.
No, my lord, that, my lord, here, my lord, the Goalpara DC has filed an affidavit saying that we are going to carry out eviction in this village. So in that list, our village is not mentioned. Considering that aspect, my lord, the learned, my lord, the honorable division bench has sent back to the civil.
This one.
Yes, sir.
The DC would not take action. The forest official will take action.
As far as Lordship, within the notified area, if anybody is inside the forest area, Lordship, the forest department is in the process of evicting.
No, it is for the forest department.
Yes,
The
Lordship.
DC has no business. DC can only do in respect to revenue.
And even though, Lordship, here the petitioners are saying that they have annexed some documents, Lordship, but those are not legitimate documents, Lordship. They do not bear anything from the competent authority. And that is why, Lordship, in our affidavit, we have categorically submitted that if they are inside the reserve forest, Lordship, they do not have any right. And
When did you make it reserve?
was
And the petitioners have been there in the reserve forest since when?
My lord, since 1964, man.
Now,
Where
tell me,
government has allowed them to stay on the land.
Huh?
Government has allowed them to stay on the land as refugee, man.
no, at that point of time, people were not concerned so much about the reserve forest. Everywhere there was a forest. Now with the forest diminishing like anything, in view of the district administration and the revenue department, Mr. Bottakuri is here to protect the forest.
Lordship, from time to time, we had to submit reports to the Honorable Division Bench when this suo motu PI was instituted, Lordship. And
I understood, but when was it made reserve? Because these people were, if they were there at the time when the reservation was not made, final notification has to be passed. Then they may have some right. But this reservation has to be made in terms of the Assam Forest Regulation. There has to be a notification under Section 6.
Lordship, there has to be a notification.
When did that happen? So their right, if it is subsequent thereto, obviously they don't have. But what the forest department has done, from my experience, they go for the first notification,
Yes.
expressing their interest to make this as a reserve forest, and they keep this matter pending for 20 years.
But here, Lordship, that timeline was not under dispute, Lordship, which is why this contempt case was initiated by the Honorable Division Bench.
But did the division bench put that question to you? So the division bench may not have been aware of what the forest department does, unless anybody has pointed out.
But here, Lordship, there is no contention in the petition that when if there was when the declaration was made that they had made any representation.
They had.
There's no contention as such in the
So
report.
whether the declaration has been made or not, that is the question.
Yes, Lordship, there is for sure a
You
declaration,
see,
but
Mr. Bottakor, I make it very clear. If it is a declared forest and a notification has already been issued in a reserve forest, the question of giving them any direction or settlement does not arise. But you cannot. That would be in violation to the forest regulation and unless they fall in a forest village. Forest village would also be another different thing where the forest department will have to take a note of it. Whether they fall in the forest village or the forest reserve forest. And then the question may also come as regards the forest dwellers. Now, in reserve forest, however, there cannot be a forest dweller. It is only in the forest village where can they have a forest dweller. Understanding. So under such circumstances, this aspect needs to be clear as to whether when it became a reserve forest, one, whether they had whether they came later on, whenever maybe, if they are claiming. Now, if it is a reserve forest, what to do? They will have to evict them, but where do you rehabilitate? You cannot rehabilitate, the DC has to do it. Something has to be done, because otherwise it will create a human problem. Isn't it, Mr. Sikdar?
that aspect, Lordship, I'll seek the clarification of when the notification was passed.
There you get the information. This is how the things has to, because otherwise, you see, this court, I'm making it very clear, Mr. Sikdar, this court, if it is a reserve forest, would not touch anything on this petition. You have to have it, but only thing is, how do we rehabilitate you? Is another question. So can it be done through the revenue department, or something has to be done, because the revenue department is also has a responsibility to see that there is of the reserve forest is not disturbed. Hello. When
1 week may be given.
Mr. I. Bottakur, the Learned Counsel appearing on behalf of the Forest Department, submits that he would obtain instructions in the matter as to when the final declaration as regards the reserve forests have been issued in respect to the forest in question. So in addition to that, he would also obtain necessary instructions as to what what rehabilitation steps can be taken in the circumstance that the land in question falls in a reserve forest. Place the matter again on when? 20 August. Any more urgent? Yes, Mr. Samaria Jamson.
Twice my matter has been listed item number 11. Lordship, kindly fix it next week, but the
Item number?
11 matter. 10 question.
The last item?
Yeah, it's not last item, madam.
2022.
Yes, madam. Yes, madam. Done.
What is the matter about?
Hello, the stone crusher unit has been closed down by the forest department in a very illegal manner. No so called notice by issue number 1. Number 2, there is a Supreme Court the order which has been passed in respect of closure of illegal mining. Now, in the name of closing of illegal mining of Kaziranga forest area, my lord, this crusher unit has been closed. It's nothing to do, my lord, with the subject matter of mining, my lord.
No, we don't take it up on Tuesday. These
Thursday,
are small matters.
Thursday, my lord.
But
Next Thursday, my lord.
no, these matters are not befitting for a Tuesday or Thursday. Tuesday and Thursday, I'm a very relaxed man. So your matter needs to be disposed of on a Monday, Wednesday, or Friday.
Very good.
So we'll take it up on next Wednesday. Okay?
But only again, it will come down, lordship, if make a little accommodation for
Huh?
mention on that day, my lord.
But
Update come back, my lord. Twice it has
it's a fix for hearing.
Yes,
How
ma'am.
did it get fixed for hearing?
Yes, ma'am, it's a small matter. Simple that the two issues are there. Lordship, see that whether mines will cover.
Whether it's fixed for hearing.
Yes, ma'am.
Something you must have done some wrong. Otherwise, why would the judge fix such a small matter in a hearing?
It comes otherwise.
Huh?
That's all.
Something you have done something.
I will make a mention, ma'am, for update.
List the matter, it will 2022 last item. The matter again on heard Mr. S. Summary, the half of the petitioner who the instant petition requires an urgent disposal. Taking into account that the matter involves a limited question, facts and law, directs the matter be listed again on 7th of August 2024. Liberty is given to the petitioner matter at 2 p.m. Yes, what are you doing? Mr. B. Gogoi, yes, we need you one thing. Today, this batch of repetitions, there's a very important issue involved. Have you issued that circular? Another notification similar to 168?
Probably not.
Then how do you take care of this situation? Everything will go.
Probably not.
You'll have a serious
Yes,
concern.
ma'am. I will definitely convey to the authorities, madam.
Because you don't have a provision for that. I've stated, but I'm fixing it on 20, the 19th. I have to ask you to file your affidavit. On 21st, I'll take it up. The matter is, otherwise, involves a very important question. Important question in a sense that whether a recommendation by the GST is mandatory or direct. And secondly, whether, because one thing you also need to take note of, because your budget is coming. You may also think about, you being a financier, I'm telling you, you may also have to incorporate similar provision which is there in your act also.
State GST.
Don't forget, because you may, then the state will have a lot of problems. So the things which have been given unnecessarily, it will be a lot of litigations. I think your budget is coming, take care of that 2015 to 24 finance bill. I think you may also, because all your provisions are parameterial,
All of them.
you may have to include those aspects. Yes, Mr. B.D. Decker.
Item 6 is that matter, my lord, right?
So that matter is a very difficult matter to do. Yes, what have you done? Why it has come up for a hearing?
Had issued rule. Lord had issued rule on the last.
When I
page.
issued rule, then the matter used to come for admission. I passed 2 orders out there that it should come up for hearing. Again, it comes up for admission. But whenever this matter should have come earlier, and now it has not come. Anyway, tell me, anything happening?
Yes, my lord, we had filed an affidavit pursuant to the negotiation process that has taken place pursuant to my lord's order. My lord, we had filed an affidavit. Of course, in that affidavit now, after making a thorough present survey of the land as well as going by the records, the authority, the deputy commissioner is raising some disputes that at that point of time, the plot of land or part and parcel of land, which they now claim were not part of that, my lord, original land ceiling case. It was some other land ceiling case. And then, my lord, other persons have already came into occupation in respect of those lands. That is one aspect of the matter. Then, my lord, subsequently, in the meantime, my lord, from the last day till today, 2 major developments have taken place. One development has taken place, my lord. I have received an instruction. If Lordship is taking up that item 6 to be given. Now, GMDA is, my lord, harping on that land, 158 bighas. The second page. The instruction. This instruction I received yesterday evening, my lord. Now, so far as, my lord, this 158 bigha 4 katha 18 lesa of land, my lord, covered by various danga NK patta number 9.
Jagadish Sharma?
Jagadish Sharma is the petitioner. Now, my lord, GMDA is expressing, my lord, their interest in, my lord, procuring that land. Those part and parcel of land, my lord, for setting up, my lord, the wholesale market.
If this thing works out something,
This may help them out because as on today, my lord, if we, my lord, connect the revenue records as well as the part and parcel of land, my lord, standing on site, we find, my lord, serious discrepancies.
but
That
how
is,
much of land are there in his possession? Now, this is dark number,
my lord, this is
9.
NK Patta number 9.
Patta number 9. And you are?
Number.
So you are in possession of Patta number 9.
I am in possession, my lord. Now, after the survey, certain persons have claimed, I mean, it was there in possession of certain occupants who were initially under me. Now, after the survey, my lord, they say that there are certain other persons and those other persons have now filed for impeachment. However, pursuant to the GMDA thing, my lord, I am given to understand that there was a survey done by the revenue and the GMD authority where the land has been found to be vacant. So on paper record, my lord, first of all, ADC made it clear that the possession is with me. At the fag end of the writ petition, they filed an affidavit stating that the possession is with some other occupants, partially. Now, my lord, I am given to understand in the joint survey again, it was found to be vacant. Now, whatever be it, my lord, if this thing works out, it resolves the entire issue, my lord. Of course, there are third parties now who are stepping in saying that.
Who?
My lord,
No, don't bring you out there.
they have just filed in the Basundhara app, my lord. On that basis, they want to get themselves.
Absolutely. And this is not government land. Government cannot settle. Don't think of settling any land out there.
If question doesn't
Something, it won't be something like this land, the trade license. Whenever they apply, you give it. Don't think.
My submission is that, my lord, this is the first development in the meantime, and this is the second development. They are filing an interlocutory application. Lordship will hear them, my lord. I have nothing to say here.
You have it, this matter for orders on certain, has the application come on record?
Applications come on record.
It has been numbered also, my lord.
List the matter again on, 13th of August.
My lord.
Initially, it was coming
No,
as
if
top
the
of the list.
Things get worked out with.
And ask Mr. Esbora also to come and see.
My lord.
Mr. Esbora, so that GMD also we can take care. Because these, otherwise it will create a huge problem again.
If these things work out, my lord, it will be beneficial at the end of the day for all concerned, my lord. Because the market will also get settled there, my lord, job avenues will also be created, and my lord, their my lord, grievances will also be redressed, my lord.
No, anyway, something will happen out there. Otherwise, this litigation, though interesting, but it has to be done, finished.
Thumbs up is top.
I'm so